microphone check this morning. Can you hear me online? Who's joining via Zoom?
Look at the resolution. Or. Proceeding.
Yes, it's coming through, Warren.
Thank you, Dallas.
So we won't get any more care one. I added it. Yeah, mine.
So you can have. Your fourth copy.
So you. Yeah.
Yeah.
With that one to the last, so what?
There's, yeah, that's. Maybe it should be 47. Are you at Holbert patio? You coming, bro? No.
Well, there was a little exchange this morning from them, coming up from talking crazy, but. What's up? Here to tell the truth. Absolutely.
Pretty.
I wanted to food.
Oh, is it?
Yeah.
All right.
Been a minute.
I know.
Great.
Thank you.
Notice in the park, it's really super cute.
What's that? Yeah, no, that's very nice. It's a nice area.
It really,
Best places to stay.
it was cute. Driving up here, I got behind every 18-wheeler that was ever
Yeah.
made on the planet. I wasn't expecting
Kind of
that.
rained halfway through and then stopped raining up.
I think we're gonna. Spotty frame ones.
Oh, yeah, you put the agenda was probably with the order. Okay, right, so you.
As if.
Yeah.
So yeah, don't worry about that.
You're covered.
I think Tara can do all.
That's right. Seems fun.
Well, I'm still in the weather, so.
Have you ever tried vitamin? B vitamin? Yeah.
Several that when you feel better.
Some stuff. I mentioned it to you
I
before.
think you did.
Will you?
I'm gonna try it.
Will you?
And then I'll put my water to it. It's not Levi. Yeah, the third thing is something that that's not with. Perfect, Lorna.
No, I said it.
They'll call for it and then you'll give them up. Yeah, if you need what you really know, we'll tell you.
Everybody wants to know, right? More than
That's a good reminder. If everybody could silence their cell phones or switch them off so they don't distract from the hearing when we begin, we'd appreciate it.
Good morning, everyone. Legislative Regular Session 101, Tuesday, October 28th, 2025, 10 a.m. Held at Halifax Complex, Ridgewood Hall. Legislative Chambers, 100 Iowa Way, Carnegie, Oklahoma, 73015. Agenda, public order at 10 a.m. And invocation, maybe for the very legislative week.
Y'all pray along with me this morning. Aho da pan ma da. Dog e da bon. E honde con dog e. And de key da da de. Dot side bedo aon tama. Dot side don ge ya on de. Dog e. Onde get collate paint so on me. No. Koi cat on bobe da do de doggy, no koi cat eye do be da do de doggy. They ki da batam doggy, a dog side dog. Koi gooba dog. Koi think they go by dog. Yatam doggy. Lord, we're thankful for this beautiful day. We ask that you bless our Kiowa people, all our relatives, all of our Kiowa families, our tribal leaders, everybody that, works for our people, even our holy people, oh, Father God, we lift them up in prayer to you today. We come before you in this legislative setting, this hearing today. We ask that you bless our minds, body, and spirits, keep our relatives in good health. And wherever there's a Kiowa today, you bless them today, especially our elders and our young people. And Father God, as my late uncle used to always says, we won't forget about our orphans and our widows today, Father God. There's a lot of people out there still in mourning. We ask that you bless those people today, Lord. And just bless our meeting here. Keep us of good mind and good spirit. I just ask all these things. I call Beto dog Jesus. Amen.
Roll call.
Carla Tattletee. Michael Primus,
Here.
Timothy Saypoodle,
Here.
Cole DeLon,
Present.
Taya Rosario, here, Ben Wolf,
Paul.
Warren Weathon,
Paul.
6 present, 1 absent.
First on the agenda. Or next on the agenda, approval of the agenda. We have one item inquiry hearing, Richard McMahon, Chairman of ACOA.
I motion we accept the agenda.
A second. Motion and a second to approve the agenda. All in favor, say aye.
Aye.
Any opposed? Abstentions? Okay, we will begin. With some questions and I'll turn it over to the legislator. Oh, that's great.
So just to provide kind of the table setting and context, so everyone's aware of the format. We're gonna try to script to make sure that every legislator has enough time to ask the questions that they feel they're compelled to do. And we're going to next up have our legislative administrator, Tracy Harris, swear in Richard Zappa, chairman of the KCOA. So it'd be great, swear in Mr. Zappa, first for all my
Yes.
Oh, yes. Yeah.
So it's red, it's not.
Yeah, it's green, it should be green.
And also, when you use it, if you kind of point it down, the microphone up in the ceiling, so that way.
Mic check. Loud and clear.
Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Absolutely.
Good morning, gentlemen. Thank you so much for joining us. Just as a kind of preliminary point of clarification, Mr. Grimm, are you here representing the Kiowa Casino Board of Directors, or are you here representing Mr. McMahon individually?
Here on behalf of KCOA board. And you have subpoenaed Mr. as the chairman.
Okay. We'll probably dive into some nuances with respect to that as we kind of delve into the question. But might come back for a little more clarification on that. As you're aware, I think there's some nuances for that. But just kind of the question, so like who did the watch? Mr. McMahon, of course, you got currently that's on TV on the track, and you go for the record, confirm kind of what's out. That's what you take.
Chairman of the Kiowa Casino Operations Authority.
And when did your present tenure on the board commence?
Yeah, I thought I was gonna get to read an opening statement.
Yeah, I mean, okay. We just didn't receive notice that you wanted to do that.
Well, good morning. I just wanted to give this opening statement because it contains a lot of the facts and as Mr. Grimm stated, he is not here representing me in the NIGC letter of concern. I am representing myself. He is here to defend actions of the board August 2022 to present. Not anything that happened during the previous term. So with that, I would like to open up this statement. I am not here to defend the actions of the 2018 to 2022 KCOA board as a whole. Other board members, or explain the quorum, non-quorum compensation plan that was already in place under the 2018 to 2020 and prior boards. I had no control or input over that plan and therefore cannot defend or question it. In my view, the cases involving the named individuals of letter of concern should be reviewed independently. I speak solely for myself as a KCOA trustee who served dutifully on the board for a little over a year, from October 2018 through October 29. When the board sued Chairman Matthew Camalti for the illegal transfer of $6 million in revenue to a bank account controlled by himself and Vice Chairwoman Robin Ahe. My service effectively ended when the third illegitimate KCOA trustee, Luke Yeku, was directed by Chairman Camalti not to attend meetings, thereby preventing a quorum. The CFR Court lawsuit ultimately led to Camalti demanding the KGC suspend my gaming license in January of 2020 as reflected in my October 2020 resignation letter to him and the Kiowa Gaming Commission. The U.S. legal system recognizes and upholds the fundamental principles that an accused person is presumed innocent until proven guilty. Let me state that again. An accused person is presumed innocent until proven guilty. This presumption of innocence is deeply embedded in constitutional due process and has long been acknowledged as a cornerstone of American criminal jurisprudence. However, the same cannot be said of the Kiowa Court of Public Opinion, where individuals are often presumed guilty until proven innocent. In this arena, certain public officials, without first obtaining or verifying all the facts, have taken to publicly expressing opinions on ongoing matters. Such actions appear intended not to inform, but to influence public perception and discredit the character of those who may challenge them. This practice undermines both integrity and fairness in public discussion. Due process is a fundamental legal principle that guarantees fairness in all legal and governmental actions that affect a person's rights, life, liberty, or property. It ensures that no one is deprived of those rights without appropriate legal procedures and protections. In the context of tribal governments, due process means that the tribe must act fairly and consistently when making decisions that affect the rights, reputation, or property of individuals. While each tribe has the sovereign right to establish its own laws and procedures, most tribal constitutions, charters, and ordinances recognize the importance of due process as a matter of fairness, integrity, and good governance. Just like in state or federal systems, tribal due process generally includes three essential elements: notice, opportunity to be heard, and decisions from an impartial decision maker. Number one, notice. The individual or party involved must be informed of the ongoing issue being taken against them. Number two, opportunity to be heard. Before any final action is taken, the individual must be given a fair opportunity to present their side of the story, provide evidence, and respond to any claims or accusations. This may occur in a hearing before a board, committee, or council. The person should be allowed to speak, present documents, and call witnesses if appropriate. From the outset of the letter of concern issued, this has not been the case. It was only after Chairman Spotted Bird heard our plea for due process that he agreed to hear our side. Number three, impartial decision maker. Those rendering the decision should not have a personal or political bias in the matter. Decisions must be based on facts and evidence presented throughout the process, not on personal opinion, political pressure, or public influence. Accordingly, in the United States and in the Kiowa tribal judicial system, no person may be lawfully deprived of liberty unless the government or tribe establishes guilt beyond a reasonable doubt, and any deviation from this presumption undermines both constitutional guarantees and the integrity of judicial proceedings. This letter of concern matter has been prolonged because the individuals named were never afforded due process. Upon receipt of the initial 2023 letter of concern, the tribe should have opened an investigation to determine whether the claims and allegations submitted to the NIGC were in fact true. Returning to the essential elements of due process, the individuals named in the letter of concern should have been notified that an investigation was imminent and given a fair opportunity to present their side of the story, submit evidence, and respond to the accusations. Witnesses should have been interviewed and all relevant facts carefully examined. Instead, the tribal attorney, upon receipt of the letter, Robert Little, responded to the letter without completing any of these critical steps. Repeated requests for due process went unanswered. It was not until our meeting with Chairman Spotted Bird in May of 2024 that we were finally granted the opportunity for due process. Chairman Spotted Bird ensured that we were given a fair hearing, allowed us to present supporting documents, call witnesses, and fully respond to the allegations. During the May 2024 meeting, Genevieve Oldbear, who served as the finance director at the casino during the period in question in the letter of concern, was called to testify via telephone. She confirmed that during her tenure, she was tasked with verifying the validity of all KCOA quorum and non-quorum reimbursement requests, and ensured that all supporting documentation was in order prior to any reimbursement being issued. During her employment, she never heard any concerns raised about how the KCOA was reimbursed until the letter of concern was submitted to the NIGC. I categorically maintain my innocence of any wrongdoing. I served under a KCOA chairman and vice chairman as a subordinate trustee with limited powers. The compensation I received as a trustee for quorum and non-quorum reimbursements was fully authorized, transparent, and consistent with established practices that predated my appointment to the KCOA board. I was compensated exactly as described to me during my new board member orientation for duties assigned to me, reference the 2017 orientation PowerPoint exhibit. The same compensation plan was also explained to me by Chairman Matthew Camalti during my interview for the KCOA trustee position. Notably, during my tenure, the KCOA board operated with legal counsel, specifically attorney Tom Zinda, present at every meeting. At no time did Tom advise against compensation for quorum or non-quorum reimbursements. In fact, in January 2019, when the enterprise was without leadership, Tom provided counsel supporting the KCOA chair or vice chair in sustaining daily operations until a successor could be appointed. He approved a daily reimbursement not to exceed $500 per day for the chair or vice chair to be on site to ensure continuity of operations in the absence of a COO/general manager. In accordance with the Sixth Amended Charter, board members were entitled to compensation for both meeting participation and other official duties performed on behalf of the organization. Historical records confirm that previous boards operated under this practice long before I joined, with payments routinely categorized as meeting fees rather than reimbursements. See historical KCOA board compensation spreadsheet compiled by Finance Director Denise Cossey in the exhibits. All work performed outside of scheduled meetings was thoroughly documented, including details of the business conducted, attendees, and purpose. Trustees submitted this documentation to the chair or vice chair of the KCOA for initial approval, after which it was reviewed and approved by both the COO general manager and the CFO prior to any monetary disbursement. Each payment represented reasonable compensation for legitimate work performed on behalf of the KCOA. You can refer to the exhibits in the binder presented to Chairman Spotted for supporting documentation. You will note that all reimbursement requests were submitted through proper channels and not directly to the CFO. For transparency, each request was reviewed, approved, and vetted by multiple parties to ensure compliance and accountability. In summary, all compensation I received was lawful, properly authorized, and consistent with both historical precedent and internal policy. I cannot defend the decisions of prior boards regarding compensation or who developed the quorum and non-quorum reimbursement schedule, as those practices were already established before my tenure. It is my opinion that the KCOA should inquire whether decisions made by prior boards, particularly those vetted by KCOA legal counsel, fall within the scope of a director's and officer's insurance claim. Such coverage often applies to allegations of breach of fiduciary duty, including claims that a director or officer failed to act in the organization's best interests through actions such as asset mismanagement or negligence. This is an avenue that has yet to be explored. The KCOA and I have previously furnished various documents to the NIGC, which recently received my testimony regarding the letter of concern. As the investigation continued, I respectfully ask this body to recognize and uphold the NIGC's authority to complete its investigation and issue a report to the Kiowa Executive Branch, as well as to respect my personal rights afforded by law. I stand ready to address the concerns expressed by certain legislative leaders in accordance with the recently enacted amendment to the Lawmaking and Production of Documents and Testimony Act of 2017, which permits testimony to be received in executive session to ensure the confidentiality of certain proceedings. I hereby present to this legislative body the recent KCOA resolution requesting that this legislature respect its own laws. I also stand ready to testify under oath to the best of my ability in accordance with these provisions.
On behalf of the KCOA board, I want to present a resolution to be included in this proceeding. And it's a resolution from the board with respect to certain confidentiality to be respected under your law.
Thank you, Mr. McMahon. Bring respect to the resolution that you're presenting, is there a reason that was not submitted to our council prior to this?
He received it.
Okay.
He was.
Thank you, Mr. McMahon, for that stirring opening. And just continuing with the softball questions and just laying the dynamic for this rest of this proceeding. You mentioned that you were obviously on the board of trustees, when it was the board of trustees, you're on a tenure. That is discrete and distinct from your current service as the chairman of the board of directors for the authority. So can you just please confirm the dates of your service as a trustee?
October 2018 through October 2019.
Okay. And during your tenure as a trustee, you were a chairman on the board of trustees.
For one meeting, I was the chairman.
That's a very short tenure. With respect to your current service on the board of directors, which has sort of been rechristened for those unfamiliar with the historical context, but I believe with the shifting charters, it is now the board of directors. Could you please just confirm when that tenure started?
August of 2022.
Thank you so much. Jason, you could put up item 70A.
Which one?
70A.
78.
For those attending, this gives a preview of the fact that we're going to be maneuvering with the elements and the technological component. So there will be a little bit of gap time between questions. Just forewarning everyone.
We don't have 78.
In terms of the 70A, so that is part of the document production digitally. And consistent with the rules, we are presenting it for examination by the public right now. This is just an organizational chart that was published by Chairman Spotted on October 1st, 2025. And if you can enlarge that top half a little bit, Jason. And this is not totally a controversial question, but just asking you, is that represents your best understanding of where the Cuyahoga Casino Operations Authority lies within the structure of the tribe?
Can you point it out? I can't read that.
Yes. So here's how you can enlarge a little bit more. So the top, you'll see executive branch. So then if you follow that midline down, and then you can see the Cuyahoga Casino Operations Authority.
And the question was,
I'm just asking, is that consistent with your understanding of where the Cuyahoga Casino Operations Authority lies within the general broad architecture of the tribe?
no, it was my understanding that KCOA sat directly under the executive branch as an independent and autonomous board.
Okay. Can you elaborate on that a little bit, just because my specific question for that is, you're mentioning your understanding is that it lies within the executive branch. but then you also say it's an independent autonomous board. So those two kind of concepts are a little bit contradictory in terms of the other autonomy implies independence from, you know, the executive branch or from any other entity as a whole. So can you please clarify what you mean by autonomous and within the executive branch?
I believe the NIGC demanded the creation of the KCOA to be an independent and autonomous board to be isolated from the political sway of the tribe.
Okay, I think we're probably getting to the same sort of meeting point, but just to clarify. Your understanding though is that the objective is for inoculation essentially against political pressures, but that it is located under the umbrella of the executive branch. Is that correct? I don't want to put words in the mouth, but is your understanding that the Kyle Casino Operations Authority is that under the executive branch?
It is my understanding that the KCOA sits under the executive branch as other boards also sit under the executive branch.
Okay, I just wanted to give the opportunity to clarify and dive into that question of the word autonomous, since it does suggest almost like autonomy from the tribe as a whole. And is that, you're not saying that, or are you saying that?
It's autonomous to be isolated from the political sway of the tribe.
Okay. Is it located within the executive branch?
As far as I know, boards sit under the executive branch.
Correct, if it's created by the Constitution. So, okay, so just this is a law because it's sort of like follow-up question to what I just asked. In terms of kind of a remark you made at the regular meeting of the KCOA Board of Directors on August 27th this year, you characterized you and your fellow directors as, quote, taking your marching orders, end quote, from the executive branch and from the chairman. Is that still your most accurate representation of kind of your understanding of your relationship to the chairman and to the executive branch?
I'm not gonna put words in other board members' mouth, but the way I see it, we take our marching orders from those in power above us, which would include the legislative, the executive branch, and the judicial branch.
So, kind of a follow-up on that. You take your marching orders from all three branches?
Apparently,
Oh, well, that's news to us. But how, I guess, fundamentally, how do you take directives from multiple branches concurrently if you're located within the executive branch?
good question. I don't have a response for that.
And in terms of kind of a follow-up question, and it's sort of just another side of the same coin, so you might not have an answer for it either, that's totally fine. If in the paradigm of taking marching orders from the judiciary, the executive, and from the legislative concurrently is like in place, how do you as a board of directors, or how do you as the chairman of the board of directors approach a conflict of directive or a conflict of opinion, or conflict of perspective among those three branches?
Can you provide an example?
No, I'm just curious actually about kind of the assertion or the characterization that you as the board take marching orders from all three branches that are of you. I'm just trying to work through that kind of template, essentially, that sort of the paradigm that it suggests, because if there's conflict of perspective, like you accede to the chairman's, you defer to the chairman's perspective, kind of fundamentally, is that correct? Or how would you characterize that? I don't want to put words in your mouth.
So the legislature writes the laws that we adhere to. So that's an authority figure. We haven't had any dealings with the judicial branch, but I'm sure if there was something to come down the pipe, we would hear that.
Okay.
We partner with the executive branch. on hopefully initiatives. But again, that should be a collaborative partnership between the executive and the legislative branch. And it was early on in 2022,
In terms of what component,
a good partnership.
those halcyon of 2023,
What's that?
those halcyon days of 2023, it's like go days, essentially, it's like. Okay, in terms of. We might revisit that in a little bit, but I don't necessarily know, just giving you the opportunity to review that organizational chart again, since it was produced by Chairman Spotted Bird. I don't necessarily know that that suggests. Like, to me, what it suggests is that the Cuyahoga Casino Operations Authority is under the executive branch, as you follow the through line down. And then you're lateral to these other elements, but you're not necessarily intermarried or. Dependent on them, but so just in terms of the organizational part, is that surprising to you, or is that consistent with your understanding?
This is the first time I've seen an organizational chart for our tribe.
Okay. That's a little surprising just because I feel like Global puts it out quite consistently. In terms of just the restructuring and communications with Chairman Spotted Bird. Jason, can you put up item 70B? This was also produced in the digital file to Mr. Graham. That I believe you have access to in the Dropbox. And kind of consistent with the general rules, readers will be available for public questions about. So Chairman Magnapond, just kind of a question mark on this social media commentary. As you can see, stated from 5 years ago, 2020 was a pretty tumultuous year. Would you agree with that?
Yes.
Okay, so as you can see, kind of the thesis there, I'm just gonna read it out for the record. Unless you would like to, I can read it just for the quotation. Okay, I don't wanna put words in your mouth, so to speak, so. Quote, people have asked, why go public with this information? I say because we are a new generation that is not going to allow this corruption to continue in secrecy. Our tribe needs to be run in complete transparency. It is what the KIC demands, end quote. So obviously there's been a change of chairman and executive branch administration since 2020, that switch occurring in 2022. Do you still subscribe to the thesis that our tribe needs to be run in complete transparency?
Of course.
And do you still feel that that perspective is rooted in what the KIC demands?
Do I feel that?
So you're kind of affirming your position here that it needs to be run in transparency. And I'm just giving you the opportunity to expand upon, here you attribute it to kind of like what the KIC demands. Is there any other elements kind of driving your perspective on transparency and why that's needed for the tribe?
I can't answer that question without more context to what this post is referring to or talking about. You can take that post at its word, and I stand with my apparent post that the KIC demands complete transparency.
They're not your questions, so I'm just kind of revisiting some public remarks that you've made and ensuring that over the passage of time, kind of your perspective and point of view is still static or consistent with what it was at that juncture. So this appears, and I'm going to say, I guess I will contextualize this. And I know that you mentioned just now that you need more context for kind of the initial precipitation, but it appears to be rooted in your prior service on the KCOA Board of Trustees. Is that a reasonable, fair assessment since it's dated from 5 years ago and dated to 2020?
Potentially.
Okay. In terms of kind of just providing everyone listening in with sort of foundational elements, we're going to be using the term trustee and director in a lot of respects interchangeably. And that is because the governing charter, governing tribal law that organizes the Kyle Casino operations. Board of Directors, it's called now, has evolved over the years, and that board of directors was previously known as the Board of Trustees. Is that correct, Mr. McMahon?
The previous board was known as the Board of Trustees. The current board is known as the Board of Directors.
Okay. And so would you agree that those two positions are effectively synonymous with each other?
Yes.
In terms of like your service now as a board of director, do you feel that, well, especially as kind of the chairman, I guess, more specifically, since you're not just the director, you're the chairman of the board of directors. Do you feel that it is incumbent upon you to be fluent in the provisions of the charter that's currently in effect?
The current charter?
Any charter at any time, like, do you feel that generally speaking, with the parameters that a change in charter obviously requires acclamation, but let's just take a whole charter, for example, since it's recent. Like prior to the current charter that was passed as the July of this year, do you feel prior to that it's reasonable for the chairman of the board of trustees or the chairman of the board of directors to be fluent in the provisions of the charter governing the KCOA at any juncture?
I feel the chairman of the board should be well aware of what the charter says.
And in terms of your enlistment of Barrow and Grimm, I'm not gonna dive into anything that I think is terribly controversial here. But there is a segment of each regular monthly meeting of the KCOA board where Mr. Graham and his associates provide an update about new laws, is that correct, or new legislative developments? Is that an accurate characterization?
No. It's not.
So when the chart provided updates about the new charter, and over the course of a couple of most recent meetings of the KCOA board of directors, Ms. Sharp has, without my recollection, provided updates on her assessment of that new charter and some other legislation. Is that an annul? Is that outside the norm?
That is outside the norm.
Okay. How often does that occur?
I don't have a count on hand, but it's a recent development because of all the current goings on.
And in terms of, I guess, the mechanical structure of that responsibility that the Sharp has executed, does she monitor new laws that have been introduced and posted on the legislative website? To your knowledge?
Not to my knowledge.
In terms of, kind of, you mentioned that you feel it would be, and I don't wanna put words in your mouth, but to the best of kind of the question and answer we just had, you mentioned that you do feel it would be reasonable and fair for a chairman of board of trustees or board of directors to be aware or fluent in the provisions of the charter. In terms of protocols or standard operating procedures for legislation at large related to the tribe, do you have a standard operating procedure protocol for how the board of directors maintains spatial awareness of incoming laws, regulatory guidelines, and outside, so the tribe, what is the standard procedure kind of within that scope?
Typically, we're notified of any changes in law by Tracy Harris.
Okay, is that the primary sort of mechanism by which you maintain spatial awareness of laws in general?
whenever Tracy provides us new legislation.
Do you feel that it is a reasonable responsibility of the board of directors to have the, I guess, proactiveness to be sort of alert to new laws or laws that could impact the casino specifically? Is that, it's a broad question, but essentially, do you feel that it's reasonable for folks serving on the board to have, let's say, a familiarity with the Constitution of the Kiowa tribe?
A familiarity with the Constitution of the tribe, yes.
Okay. Do you feel that it's reasonable for folks serving on the board to have an awareness of laws in general that be visited that might impact the operations of the KCOA or the operation of the casino?
When they're presented to us by the legislative branch.
Okay, let's say a new board member comes on to the KCOA. Obviously, the legislature does not provide orientation for new board members. So how does a new board member become up to speed, so to speak, on the Constitution and or the laws in place?
We provided a copy of the Constitution and the KCOA charter.
Okay. They literally provided with any other laws.
I don't know.
And you as a board, does the board under your authority as the chairman provide only the Constitution and the charter to folks who come on board as a director?
Josh, it would be hard for me to say because typically those documents are sent out by KCOA secretary.
Okay. Do you generally maintain spatial awareness about what the KCOA secretary sends out to your boards?
I trust her to send out all pertinent documents.
Okay. So therefore, the most recent kind of appointed to the board, Sean Douglas, so you don't know for sure what kind of documentation, what the documents about.
I do not have firsthand knowledge of what was sent to him.
Okay. Jason, can you pull up item 15C? That should be on the line.
Did you say 15C?
It's part of 15, Bill.
Should be in item 1. Yeah. Okay, Mr. McElhan, it's up on. And you need a minute to dive into the binder and find it. So kind of in that vein of transparency that we were just talking about. Do you recognize this correspondence from Chairman Spotted that was initially transmitted according to the dates on March 7th, 2024, and again on April 15th, 2024?
Yes, I recognize that letter.
How would you synopsize this letter?
I wouldn't. It's it priest evidence is a second letter to me. Titled NIGC letter of concern and alleged misuse of gaming revenue by the Kiowa tribe.
And in terms of kind of the elements there, if you'll indulge me for a moment, I will just provide a little bit of context for folks joining us. So, I believe most of the people who are either listening on Zoom or in person are probably unacquainted with, you know, the Wellspring documentation related to this inquiry. And so this is written communication transmitted by Chairman Spotted in the spring of 2024 to, twice on the aforementioned dates, to you, Mr. McMahon, also to Jim Poe, Susan Dunlap, James Kennedy, and Luke Yu. I believe all of those aforementioned folks serve concurrently with you at one juncture or another on the East Wing Board of Trustees, generally between the 2017 and 2020 time period. Was that a fair characterization?
That is correct.
Okay. And in terms of this particular document, if you count the cover page of April 2024, the total for the fund was 5 pages in the space, and it is signed by Chairman Spotted. And it's a sort of response or spurred by a November 2nd, 2023 letter to the tribe from the National Indian Gaming Commission, identifying and establishing concerns about alleged statutory violations of tribe law and federal regulations and violations of the charter governing the ACOA at the time of the events in question from 2017 to 2020. In terms of this particular correspondence, correct me if I'm wrong, Chairman Spotted Bird delineated, well, I'm saying Chairman Spotted Bird, you mentioned before about little, but you know, I'm just going to, for the purposes of this particular question, note that Chairman Spotted Bird signed a letter and that's the signatory, that's what I'm going to attribute it to. But over the course of the 4 pages, he constructs kind of the specific statutory violations that occurred, and also calculates amounts owed back to the tribe for each recipient. And so those amounts varied from, you know, Mr. Poe, done that to you, Mr. McMahon, to Mr. Gaku. Those, of course, are different amounts. We believe the amount identified in the calculations signed by Chairman Spotted Bird, $32,100 for you. And you were kind of on the lower end of the identified these overpayments that are needed in this correspondence.
Alleged overpayments.
Yeah, we can, well, I will stipulate that, I think that there is, obviously you have a different perspective in terms of
Obviously,
the statutes in place at the time and the provisions that govern them. But let's establish that you are disputing that those were overpayments, but you are not disputing receiving those funds. Is that a fair assessment? Is that a fair characterization?
I think I answered that in my opening statement, which you can refer to.
Okay.
Unless you have knowledge that I don't have.
It's a pretty straightforward question. So, like, in terms of the opening statement, I mean, that's another reference point. So for clarification, I am conceding for the record that you are disputing that these constitute overpayments. But my question is, that's a discrete and separate distinct question from, did you receive the monies?
I received quorum and non-quorum reimbursements.
Okay. And that is what is that money, whether we call it quorum or non-quorum reimbursements or overpayment, it refers to the same sort of pool of funds, correct? I'm giving you the latitude that I'm saying we can disagree on the verbiage applied to that pool of money. But both of those terms apply to the same fully plowed crush.
I disagree.
Okay, so you're saying you did not receive.
I
That's
received
not the one.
quorum and non-quorum reimbursements. That was the policy when I was on the board at that time.
Okay. It's really not a trick question. I'm just trying to essentially establish that.
Okay, like, we're clear on the record.
Yeah, but we're essentially. Alleged overpayment, and then quorum versus non-quorum. It's a dispute about the nature of the money, but it's not a dispute about. The funds themselves, correct? Like you received payment and you are characterizing it as. Quorum versus non-quorum, whereas NIDC correspondence and. Other folks that led to NIDC are characterizing as overpayments, but it's the same amount. Again, it's not a quick trick question, I'm just getting at the fact that we're effectively not talking about two separate situations, we're talking about one specific situation. In terms of kind of this letter. 2024. Chairman Spotted writes it here, and Jason, you might need to scroll down a little bit. Chairman Spotted writes in here. To date, I have not received any definitive response from you. Was that an accurate characterization in April of 2024?
I don't recall.
Okay. Would you trust that characterization? You don't recall, but would it be? I guess, have you ever known Chairman Spotted to mischaracterize from back top points in other words on?
I can't say that Chairman Spotted has done one.
Okay. Therefore, do you have any dispute with that characterization?
That what characterization?
The characterization that Chairman Spotted puts forth in April 2024, he says, I'm sending you this letter again because I have received no definitive response from you about the contents of the somehow. Do you dispute that characterization of Chairman Spotted or no?
If he is stating that he hasn't heard from me, then he probably hasn't heard from me.
Okay. In terms of the assertion there, I would actually say it's not. I would actually say that Chairman Spotted characterization there is not entirely accurate. In terms of Jason, can you pull up the February 2nd, 2024 correspondence? We will give you a second to do that.
February 2nd, 2023 or 2024? This is it?
That is earmarked for the dive during a second. But that's not it, it's February 2nd, 2024. And speaker, I'm gonna make a motion that we take a 5-minute recess, so Jason can locate in his files the next document.
Yes, we are. Recessed for 5 minutes.
You need a motion.
Oh, maybe a motion. I second it. We have a motion and a second to take a 5-minute recess. All in favor, say aye. Aye.
I hope everyone got their drink of water. We're probably good for about another hour, an hour and a half, and then break for lunch. So there's a headline in sight. You're not, in terms of this particular documentation. Believe that is the end of binders. It's definitely in the data box provided yesterday. So Chairman McMahon, as I was mentioning, in terms of that April 2024 characterization by Chairman Spotted-Bird, where he says he is not receiving defendant responsibility regarding kind of this general NIGC matter. I was saying that I actually think that's a little bit inaccurate because we have the February 2nd, 2024 correspondence from you to Chairman Spotted-Bird, to the Vice Chairman at the time, Jacob Zotai, and to Robert Short, who was a Kiowa Gaming Commissioner. Do you recognize this correspondence?
Yes, I wrote it.
In terms of this particular kind of component, I think in the second letter, you kind of flatly state that you will not repay any compensation I received while serving as a case of the board of trustee from 2018 to 2020. Is that an accurate characterization of your continuing position?
It's right there in black and white. Yes.
Okay. I'm just clarifying that you mentioned you wrote it, but that's the kind of your current position now.
Right.
Okay. In terms of your articulation of that particular kind of sentiment, we'll dive into some of the complexities and the nuances as we go along. But have you ever asserted that it will be, quote, a full day ballot, end quote, before you repay any compensation received during your term in the case of the board of trustees?
I don't recall. Do you want context about why this letter was written?
Yeah, we can dive into it. Yeah, I know that. So,
Okay.
I mean, we're gonna unpack it, so hopefully the opportunity will organically arise.
And just for the record, the legislators will ask questions.
Okay. I will follow the rules, as you know, speaker, since none of the legislators are gonna be questioned today. But I will do my best to provide you with the opportunity to unpack organically concurrent to kind of my questions. So, in terms of the particular correspondence, since it does stipulate, or you do kind of acknowledge that is your current position, now a year and a half later. I guess my question is related to the sequence that says, quote, it was not until a disgruntled former COO/GM in a retaliatory effort to try and smear my integrity and my service to the tribe, raised concerns with a falsified document declaring potential misuse of gaming revenue. This same COO/GM was rightly terminated from his casino position due to his own disgusting behavior. End quote. Do you stand by that characterization as the origin of the NIGC investigation?
At the time, yes, it was characterized that, and we have sworn testimony to the fact that there were parties present when the former COO/GM knew that they had lost the election, and in a meeting publicly stated to those in attendance of that meeting, we've got to do whatever we can to make sure Richard and the former board members don't come back on the board, because if they do, they're going to fire us. So I stand by that characterization. Now, if there were others part of that letter, I don't have knowledge of that.
Okay, so taking that characterization, you state that it was after this former COO/GM, quote unquote, and others lost the election. So you're stating that this was precipitated, at least in part, from 2022 or what would be the date?
I can't go back and give exact dates, but I know this precipitated. After we sued Chairman Gamalti. For taking the $6 million.
Okay, in terms of your characterization just now. The last two elections were in 2022 and 2024, at least with the last minor election. Do you, are there, is that a fair characterization to the best of your recollection of the most recent two elections?
Again, I don't have the exact timelines. I didn't keep a document of specific dates regarding this, so I don't have anything to refer to.
When was the COO / PM in question?
My apologies, I didn't have that pulled up.
I can potentially follow along, but if you have it pulled up, just let me know. It was after you came, well, it was after the election, correct?
Well, the investigative report was finished and submitted to the board in January 9th of 2023, so it would have had to have been after. The investigation was completed that the gaming commission revoked his gaming license.
Okay.
In response to this legislative, not, my apologies, not legislative, this investigative report.
Okay, and then. Was Chairman Spotted Bird in office when this individual was terminated?
Yes, he was.
Okay, so that would be after July 2022. Yeah, 2022. Is when Chairman Spotted Bird was sworn in. So we're looking at sometime between after that, around the 2023. Okay,
Correct.
so in terms of the letter, we could get that back up.
I have that PowerPoint too on the dates if you need it.
With respect to the letter, it's open here that I want to dive into a little bit more thoroughly. And that reads, Jason, you can potentially scroll along and try to find this. I think it might be towards the end. Quote, as an appointed person, I operated under the direct supervision of my superior, e.g. the tribal chairman, the ECOA chairman, and the Kiowa Gaming Commission. In terms of that quote, you state that you operated under the supervision of others. Is that how you would characterize your entire tenure on the Board of Trustees from 2020 to 2020?
I believe we kind of talked about this earlier today.
Well, we're talking about it again.
I would say that is a fair characterization that we work with the branches of government for which we serve.
So just in terms of kind of the element of as an appointed person, so quote again as an appointed person, I operated under the direct supervision of my superiors. We'd be the tribal chairman, the KCOA chairman, and the Kiowa Gaming Commission. So where do you feel that appointees, they're not the KCOA chairman in this formulation? Do you feel that they do not have the responsibility to familiarize themselves with the charter and its provisions?
Do I feel that the appointee what?
So in this particular kind of formulation, at least as I'm reading it, it seems to place appointees to the Board of Trustees, so just general trustees. It seems to position those folks subordinate to the chairman of the Board of Trustees in this kind of paradigm that's laid out here. And obviously, the chairman of the board has certain responsibilities that are discrete and distinct from just regular trustees. So my question is, do you feel appointees to the board, do they have less responsibility than the chairman of the board to familiarize themselves with the charter or its provisions?
No,
Okay. So you feel that this is gonna be, you know, a little bit tedious for you, but in terms of just articulating another way, you feel that all trustees sort of have concurrent responsibility that's commensurate with each other to helps with the charter and its provisions.
yes,
Okay. In terms of the February 2024 letter, that's still up. You're right. But points in your NIGC letter argue legality and attempt to hold everyone to language in a tribal document. This appears to be selective enforcement of perceived grievances. So that is a little bit confusing because I guess as written, again, the quote is, points in your NIGC letter argue legality and attempt to hold everyone to language in a tribal document. Why is it bad to hold everyone in language to a tribal document, especially tribal law?
restate your question.
Okay, I'm going from a quote that you have in here, from Jason, if you can highlight it, it's like the first sentence of the last paragraph on the page right now. It's points in your NIGC letter argue legality and attempt to hold everyone to language in a tribal document. So my question is, why is it bad to hold everyone to language in a tribal document? Especially if that document is the law of the tribe.
I didn't say it was bad to hold everyone to language in tribal document.
Well, the next sentence is, this appears to be selective enforcement of perceived grievances. So the implication there is that it's negative. I'm also a little bit confused about how the first sentence states that the chairman is trying to hold everyone to a standard in a tribal document, that being the tribal charter, that gives you a charter. But then at the same time, that's selective. So is it, seems like, would you agree that holding everyone to language with the standard is contradictory to selectivity? Because at least from my perspective, holding everyone to the same standard is the counterpoint to selectivity.
What should have happened is a proper investigation performed. And that standard would have been set by some authority figure.
Okay, so in terms of, do you feel that it is a bad thing, as this letter suggests, to hold everyone in language, to language in a tribal document?
I'm still trying to wrap my head around your question. I don't understand what you're trying to get at.
I mean, I'm asking you about words you yourself wrote.
Correct, 2 years ago.
Right, and so, I mean, the semantic articulation is how you presented it, so I'm asking about, I mean, does your semantic articulation of the way that you convey things change, like, over the course of 2 years?
I think there's possibility it can, once you learn more evidence, review the circumstances.
So here, yeah, and the question is, holding everyone to language in a tribal document, is that a bad thing?
Holding everyone's language in a tribal document, no.
In terms of the 2024 that you wrote to Sharon Cloudberg, You describe the rate of compensation for KCOA Board of Trustee members. And you state that it was $1,000 per monthly quorum meeting and $500 for any meeting outside of a non-quorum. Is that a fair characterization of your, again, that's a quote from you, but I'm just giving you the opportunity to clarify whether that's the position you still hold.
That was the compensation plan in place during that tenure on the board.
Okay. In terms of the definition of quorum versus non-quorum. Where is that in the Sixth Amendment Charter?
You would have to get testimony from previous board members who created that policy. I told you in my opening statement that I was not part of that creation process. This compensation plan was in place long before I came on in 2018.
Well, I'm not asking you about the creation of the policy or the historical.
You're asking me for definitions of form and non-form, which I don't have.
Well, I'm asking you because we previously discussed. The element of do KCOA directors and do KCOA trustees have a responsibility to be familiar with the provisions of the charter in place at the time of their service. The Sixth Amendment Charter was in place for the entirety of your service of KCOA Board of Trustees from 2018 to 2020.
That is correct.
So I'm asking you, where's non-quorum defined in the charter?
You would have to ask previous board members who developed the compensation plan that described quorum and non-quorum.
Have you read the Sixth Amendment Charter of?
I have read the Sixth Amendment Charter.
Okay, so why would I have to ask? Previous board members. If you have read the Sixth Amendment Charter, why could you not tell us where the definition of non?
Section 13.15 compensation. The last part, the trustee shall also be entitled to receive reimbursement for any reasonable expenses incurred in connection with the performance of the trustee's duties. It is my understanding that during that time, Attorney Tom Zenda sat at every board meeting. And it was that language that Tom Zenda approved for the quorum and non-quorum, is my understanding. Now, Tom would need to be brought in for testimony to say that, but that's how it was explained to me. And that's how it was explained whenever I joined the board, that the board received quorum and non-quorum meeting fees or reimbursements.
And the section that you just read, where is non-quorum? The term non-quorum used.
I believe that is open for interpretation.
So the term non-quorum, is that located within the Fifth Amendment Charter?
Not to my knowledge.
Okay. So. In terms of. How you utilized it. In the context of your term of service.
How the board utilized it.
Well, you're actually suggesting that there was discrepancy, or I would have to. Dive into the historical context to get a definition, as what you initially said, so.
No, that's not what I said.
Okay, clarify what you said. What would I have to go, what would the legislature have to go?
Because I did not create the quorum and non-quorum compensation plan.
Okay, but I'm specifically asking about.
If that is in place. When I joined the board. And that's the way we're compensated. Why would I question that? Especially when you have legal counsel at your side saying. This is proper.
Well, that sort of circles back to. A question, which was, do. KCOA trustee members have a responsibility to be present in the charter that is in effect at their time of service? You said yes. So my question is, in terms of non-quorum, we've also established just now, I think, collectively, that non-quorum is not utilized as the word non-quorum in the Sixth Amendment Charter of the KCOA. So, is there the possibility that there's discrepancy in how a word that's not defined, not included in the KCO charter. Is perhaps interpreted differently and utilized differently by different members of the KCOA.
I can only answer for myself. I can't answer for how other cases, members of KCOA would respond to that question.
How did you ensure that your understanding of the definition of non-quorum aligned with the understanding of non-quorum among the other members of the board at the time?
It was explained to me by the leadership at the time that that's how the board was compensated, with quorum and non-quorum reimbursements.
In your February 2nd, 2024 letter, you actually state, quote, "It was the social norm for how the board operated at the time," end quote. In terms of the characterization of the $1,000 from a whole board meeting, and then also the $500 for any meeting outside of a non-forum for performing official business as a trustee of the board. In terms of kind of that component, do you feel that social norms supersede the provisions of the KCOA charter in effect at the time?
I think having a legal opinion on quorum and non-quorum and that being the accepted compensation plan.
When there are differing legal opinions, how do you determine as a board what the accurate opinion is?
Having not been in this situation, I don't know. I can't answer that question.
In terms of social norm, do you believe that social norms supersede tribe law?
You know, we can pick apart my verbiage and how I wrote the letter all day long. But we need to get back to the fact that the compensation plan that was in place when I served during 2018 to 2019, the board was compensated for quorum and non-quorum reimbursements.
Why does it frustrate you to revisit your own words?
Because you're picking apart social norm. What does that have to do with the fact that the board was compensated for quorum and non-quorum reimbursements?
I just asked you if social norm in your articulation here supersedes tribe law.
No, social norm does not supersede tribe law. In what context?
I'm asking just as a
You're asking a general question. In what context would social norm supersede tribal law? I mean, you're asking a basic question that's leading.
Do you need a moment?
No, I'm fine.
It seems like I just want to be sure because it seems a little bit frustrating on your part. I want to make sure.
It's frustrating because if you're gonna pick apart every single phrase, we're gonna be here a long time, but I'm here for the duration. I'm here to answer all the questions.
Well, unhappily, but apparently, but
That's
again,
your characterization, sir.
well, I'm reading the body language of the. You read about frustrating to you, so I'm actually interpreting your words. But again, this is just your own kind of dictation, your own expression, so I'm trying to ascertain the fundamental pieces that you're operating from and some of the kind of articulations and arguments you're making. In terms of, I guess, this sort of formulation of social norms prevail. And you also mentioned you were under the direct supervision of your superiors, e.g. the charter chairman. And so in that Facebook commentary where you called for transparency earlier, you know, and other spots have been very vocally critical of Chairman Kamalsi. So have there been instances during your term under Chairman Kamalsi where you were hesitant to express an opinion counter to that?
Were there instances that I was,
Under Chairman Kamalti, were you hesitant to express opinions or positions that would counter to Chairman Kamalti?
there may have been? Are you referring to a specific incident?
I'm just trying to gather and get an idea of, at least my impression is that, particularly that's the media, you were very vocally critical of Chairman Kamalti. So it did not seem to me, at least, that you had any reservations about expressing opinions that would counter to him.
When Chairman Kamalti's character was exposed and it wasn't in a positive light, my opinion about Chairman Kamalti changed. And my expression and disapproval of the way he ran things is what eventually led me to getting my license revoked. After we sued him in tribal court and CFR court for taking the $6 million.
Okay, so then, given that context, again, it sounds like you have no problem standing up to Chairman Kamalti, taking a position counter to him. Why did you rely on him for your own account so heavily in terms of taking the lead of what the social norms were of the board of operations, the Cabo Casino board of trustees at the time?
You're talking about when I first joined the board and my relationship with Chairman Kamalti was good before he started showing bad character?
Well, your characterization earlier was that as an appointed person, you rely on the tribe chairman to set the standard, and then this letter as well, you state that the social norm prevailing at the time we led you to, rely on the sort of behavior that was established in terms of the payments. So I'm asking, given your it does not seem that there was any hesitation as we agreed to stand up to Chairman Kamalti and ask questions about other stuff. So why did you rely so heavily on his standard, if that's how you're characterizing it in terms of the payments, non-foreign versus foreign compliance?
In the beginning, when I first joined, are we going back to the same thing?
Well,
In the beginning, when I joined the board, we had a good working relationship.
and you continue to rely on that definition throughout your tenure on the board, though, correct?
What definition?
You're stating that at least to the best of my understanding, you're articulating that you relied as the phone person under the direct supervision of the tribal chair. And the social norms of the time were set by kind of a top-down dynamic. And so my question just is, why would you rely on Chairman Kamalti's lead in that respect? Like that sort of, as an appointed person, you're relying on the tribal chairman throughout your tenure on the board. And you were on the board even after your dynamic with him from a sale or salary, correct?
So you're saying that I relied on his leadership and governance even after the relationship turned sour?
Well, you continue to receive your payments for the farmers with non-farm structure.
I didn't receive those payments from Chairman Kamalti.
Speaker, I have a point of order. I think we're over time before we can give back our time to Legislator Cole at the end.
Okay.
Just want to keep us on time.
Yeah.
Yes.
Okay.
Okay,
We got a couple of the legislators that we got to go through.
yes, and at this time, we can move forward with
Let me go next.
questions by Legislator Wisdom, District 7.
Good morning, Mr. Magnon. Thank you for appearing before this legislature. I'm gonna run through some of, I guess my highlights just on status, timeline in regards to the NIGC investigation. To your knowledge, has the NIGC investigation officially concluded?
No.
And in communications, on social media networks, you stated that KCOA members were investigated and found innocent in both wrongdoing by the tribe and the NIGC. Do you deny that?
No, I do not deny that. I made that comment after Chairman Kamalti performed his investigation and issued the letter to us, in which he stated that he found no evidence of wrongdoing.
Okay, so you have documentation to state that.
Yes, that was presented in the file that was sent to the attorney.
Okay. The legislature has requested a change, I guess, official notification from the tribe, sent to the tribe or the KCOA suggesting an update to the investigation. Has any investigation happened since since the third response was sent by the chairman?
There actually has been no investigation, no formal investigation. There has only been an informal investigation.
By the NIGC?
The NIGC is reviewing testimony. I wouldn't consider that or classify that as a formal investigation.
So no formal investigation has been completed by the tribe and or the NIGC?
Lawrence performed an investigation. I don't know if you can classify that as a formal or informal. But he afforded us an opportunity to present our side of the story, present documentation and facts, and take witness testimony.
Okay.
So.
And that's after he concluded that, he sent that second letter saying that he found, there was no wrongdoing by the KCOA board, correct?
And at that time, yes, that is correct. And at that time, he told us verbally that he felt this issue to be concluded. And then when I made this Facebook post, we had no knowledge that the situation with NIGC had not been concluded.
Okay. So it's still ongoing. You said earlier it's continuing, right?
They are still reviewing our testimony as well as all the documentation, the same thumb drive that Jason received,
Okay.
they received.
So prior to this inquiry made by the hearing, what compliance procedures or internal controls were in place at the casino to ensure regulatory adherence, specifically around compensation for KCOA board members?
So the quorum and non-quorum reimbursement policy went away in 2021, I believe. Under KCOA Chairman John Tsuda. They went away from the old meeting fee reimbursement compensation plan to a monthly stipend.
Monthly stipend, and that continued when the new charter was accepted or voted upon by the legislature?
As far as I know, yes, we are still operating under the monthly stipend from established.
And what is the current monthly stipend KCOA members receive?
$4,000 a month.
$4,000 a month.
Correct.
For board members.
That's correct.
And are there any other member of board, are there any other meetings beyond that?
No.
Just one meeting a month?
There are multiple meetings per month, but everything is covered under the single stipend payment.
Single stipend payment.
Yes, there is one stipend payment.
Okay.
And we can have.
As many meetings as you need, but you get the single stipend payment.
That is correct.
So under the new charter, are you able to change that stipend?
Under the new charter,
Mm-hmm.
I have not memorized the new charter yet, as it is still very new. So I can't provide you an accurate response to that question.
Okay, and I know you were already operating under the same compensation plan that they've been operating under the old charter. In 2018, right?
That is correct.
Okay, and what were the meeting fees? What was the meeting fee at that time?
In 2018,
And
in 2018, there was a $1,000 quorum fee and a $500 non-quorum fee.
okay. All right, thank you. So as the KCOA currently provided all requested documentation to the NIGC in the course of conducting their inquiry.
Has the KCOA provided everything?
Yes.
I feel that we have.
And what has there been any correspondence? When was the last time you heard from the National Indian Gaming Commission?
I can't give you a specific date. I can follow up with a specific date. I don't want to say something and not be correct.
Sure, sure, but,
My last correspondence was actually this morning. I sent him the same thing that I testified with my opening statement.
okay,
Because that was basically verbatim what testimony I gave in September at the NIGC.
so you brought up allegations of a former employee that contacted the NIGC and brought up questionable authenticity of documents provided by that employee. What steps has the KCOA taken to address or investigate those allegations of document falsification internally?
As far as current ongoing document
Yes.
falsification,
The falsification with the former employee. What has the what allegations have been looked at by the KCOA? Or, I'm sorry, let me rephrase my question. I'm getting confused here. What steps have the KCOA taken to address or investigate those allegations made by the former employee? The one that made those allegations against you all.
we haven't,
You haven't done an internal,
we haven't done an internal, no, we solicited the initial response to NIGC and then yet to receive that, so.
so you didn't have any kind of internal investigation on that former employee turning over documents?
No, there was no formal investigation on that one named individual.
Okay,
And probably because we don't have verification of who actually sent the first letter to NIGC.
okay. So is it speculation then?
It is speculation, yes.
There's no formal investigation as to who reported to the NIGC, is that correct?
There's speculation and then only one witness testimony so far that says this person did what they did. But there probably were others.
So there are no other outcomes or ongoing reports resulting from any investigation of that former employee?
Not for the letter of concern matter.
Has the KCOA right now, in the chairman's letter to the NIGC, he had mentioned a corrective action plan in response to the letter of concern sent by the NIGC. Is there a current corrective action plan in place that you know of being executed? But by the tribe itself, it could be the tribe, KCOA, a current action plan crossing branches.
I'm not aware of a corrective action plan.
Cause the chairman will ask him tomorrow, but the chairman did say there was corrective action plan in place. And that the tribe was looking into or making an inquiry, we won't call it an investigation, to use your word, inquiry. But I have not seen a corrective action plan on how we're going to make sure that this doesn't happen again.
Well. Any meeting stipend overpayment issue was mitigated in 2021 when the board adopted the monthly stipend.
The monthly stipend system.
Right, there's no way that a current board member can receive more than what the monthly stipend amount is. You can't submit any other meeting fees. So
You can't change your salary.
you cannot change your salary, no.
Yeah. So currently, from the KCOA, what steps are being taken to ensure that transparency and ongoing communication with all branches of government and including tribal citizens? How are we gonna be transparent with the outcome of the NIGC's response moving forward?
With the outcome of their response that they get to give.
Yes,
I guess that would be probably a chairman of the tribe.
a letter, nothing coming from the KCOA itself.
We haven't thought about that, I mean. I would imagine that any future correspondence regarding the letter of concern can be published by the chairman of the tribe. Speculate, I'm not gonna put words with actions on it.
Sure, but you do agree that there needs to be some transparency for the citizens of the tribe as to what is going to happen with their casino enterprise board moving forward. Do you agree?
Absolutely.
In your own word, in your own mind, how can the KCOA strengthen compliance, governance, and accountability to prevent this kind of thing from happening again?
Well, I think you've got to go back to August 2022, whenever I came back on this board. We put policies and procedures in place. We put a credit card policy in place. We put travel policies in place. The board is bound to the monthly stipend that cannot be changed. So no board member can request over and above what the budget allows. So there are plenty of checks and balances in place now that were actually put in place before I came back on this board. As I stated, Chairman Tasuda at that time was the one who put the monthly stipend in place, and I think that mitigates anything from happening. And just for the record, there has been no malfeasance, overpayments, or anything of the like that this current board has been subject to.
Thank you for responding to that question. I guess, could you provide, I mean, you coming on board 2000, prior to this new board, right, when you came back on, when did you begin? Should we state when you began your first term?
This current term?
No, the first term, the first time you were on the board.
2018.
2018. So when you joined the board, you're saying you were not aware of an overpayment problem, alleged overpayment problem.
Correct.
You were just following, you fall in and you got paid just like everybody else did.
There was no discussion. There was not an issue with any overpayments.
Okay.
Until after my term on that first board.
Okay. I asked that question because, I wanted to know the process. Was it ever discussed at any board meeting? I guess my question is, was it ever discussed at any board meeting? Everybody's gonna get paid this amount for every quorum and non-quorum meeting.
So yes, and that was part of my opening testimony. And the document that I gave Mr. Primus was when I came on the board as a new board member, I participated in a new board member orientation, and that happened in 2018. The chairwoman Dunlap at that time reused the PowerPoint orientation set from March 27th of 2017. And on page 11, it describes the compensation for me. And it showed a fixed stipend, $1,000 per meeting, regular and special. Reimbursement for any reasonable expenses incurred in connection with the performance of trustee duties. Reasonable expenses include $500 reimbursement for trustee duties outside of charter identified meetings. Construction site visits, town halls, and any KCOA business with supporting documentation. Also including documentation of business activities and purpose must be submitted through chairman, CC to CFO, and general manager and COO. So that was the compensation that was described to me when I joined the board.
Okay.
So.
There was no official meeting like to change that at any time.
Correct.
That was my question.
It was already in place.
So you understand that our concern is we don't want a board to just change it whenever they want to, right? And so that's why I asked that question. I wanted to be clear and so you can clarify for this legislature. You are not authorized under the new charter to change your stipend at any time now. It's budgeted by the tribal budget. And that's how we make sure that we're compensating all the board members currently.
Correct.
Okay.
And I think I'm in agreement that all of these issues that we're addressing with the letter of concern have been mitigated and were mitigated in 2021.
Excuse me. At this time, I make a motion to enter this exhibit into evidence
This is,
This is the opening statement, which Mr. McMahon
okay,
handed to myself.
I'll second the motion.
We have a motion and a second to send it into.
Your opening statements, which is your opening statements.
All in favor, say aye.
Aye.
Any opposed? Any abstentions?
What is it?
It is the opening statement, I did, that would be the first one, second, third one.
Well, Mr. Franklin, thank you for answering my questions. I had all my questions written out, and you've answered a lot of them from legislator DeLon's testimony, so I'll leave that.
Okay, at this time.
Okay, looks like our catering is here, so in the interest of ensuring everyone is in motion room. I make a motion to recess right now.
I have a motion and a second. To recess for 1 hour. It is now 11:59.
Aye.
All. Position. All in favor, say aye.
Aye.
All opposed? Any abstentions? Or is it? At this time, I'd like to recognize District 1 Legislator Kyle Atabalty.
Yes, I'd like to yield my time to Co. Co, we,
Yeah, sound great. Thank you, Kyle. Jason, if you could pull up document 22, and welcome back, everyone. Now, this has sort of been touched upon superficially, but I'm going to go into a bit more detail. So this was the Facebook comment published to Facebook on January 25th, 2025. Earlier this winter. And of course, it says, keep posting this document like it's constant. Fact is, all cases were listed on that were investigated and found innocent of wrongdoing by both the tribe and the NIGC. It was also proven that this. I'm going to give Jason a minute to. Just slow that one down. This document was falsified in an effort to smear our names to distract from the former employees' own illegal activities. The petitioner's numbers were drafted by a disgruntled employee who was under investigation. Roughly, is undiscussed related.
It's still underway on the former employee.
And so Chairman McMahon, I'm just diving into that. I know we sort of touched base about this during the last stuff. But obviously, correct, the investigation was not concluded in January of 2025.
Correct, but that was unbeknownst to us.
Had you received any communication from the NIGC or from Karen Spotted Bird prior to publishing that post that the NIGC investigation was about?
No, as stated earlier, after Jared Spotted conducted his investigation or his inquiry, whatever you want to call it. He issued a letter to NIGC stating that he was comfortable with the result of his inquiry. We provided sufficient supporting documentation, witness testimony, verifying that the quorum and non-quorum fee was established before we were on the board. It was not something that we created. He was comfortable with the results of everything that he looked at, all the testimony provided that we didn't do anything wrong. We operated under the compensation plan that was in place whenever we came on board in 2018.
Okay, but you've never received any communication from the NIGC of the investigation. That included the fact you.
I received no communication from NIGC. The NIGC only communicates with the tribe.
Okay, well, I'm just trying to ascertain why it's presented. Fact is, by both the tribe and the NIGC, quote, all cases were listed.
It was a misstatement upon my part,
Okay.
because at the time when Chairman Spotterberg cleared us, as I stated earlier, he said, I think this will satisfy the NIGC in their inquiry because you all have provided sufficient documentation, information, testimony, and I find you not guilty. So I feel confident that NIGC will clear you as well. Was it wrong and premature of me to post that? Absolutely, I admit that. But that was not, as you have characterized in other meetings, me trying to lie to the people. I would never lie to the people, and I would never make any comments that would, try to falsify however you're trying to characterize.
Well, to be precise about the verbiage, I never said that you lied because that describes intent. I said that you propagated falsehood, which is correct because that is a false statement.
Well, if I did it intentionally, that was not my intent, and you know it was not my intent.
I don't know, that's not your intent, that's why we're.
Well,
here.
I'm making it very clear on the record that there was no intent.
Okay, Jason, can we go to document 8I?
8I, okay.
And pull 8H as well.
BH.
We'll get that there again.
Yeah.
But while we're on the by. Chairman McMahon. On this document. Submitted on around May 20th, 2025. From the legislature. Signed by Speaker Primus. And it's kind of synopsizes. The question that we had at that time, which was, you published this comment to Facebook. And what exactly, is there any developments that led you to conclude that the NIGC investigation have found everyone innocent of wrongdoing? Jason, if you can switch to 8. And this is a follow-up to you after you responded to us. And your response to us is included in the quoted part. And you might need to enlarge that basically. But you state that you need documentation of the screenshot question because you are unable to respond to hearsay. How do you define hearsay?
So when I received the legislative letter talking about a Facebook post I had made, there was no context provided. You didn't provide a screenshot, you didn't reference which. So unless you provide a context for what I'm supposed to answer to, it's hearsay in my opinion. Whether that's a legal opinion, that's not up to me, but you provided no context. So I appreciate the follow-up letter wherein which you did provide the context, and I admitted to posting.
So, because you don't think that hearsay is a term that applies to your own words. I guess my confusion is, we don't remember posting commentary about being found innocent by the NIGC. That seems like a pretty, once in a lifetime event just to be found
You didn't
innocent by
provide
the
context.
NIGC.
You didn't
So
provide me with.
how
the
often have you
Facebook post.
been, how often have you been posting about being found innocent by the NIGC?
You didn't provide context.
We provided context.
In a follow-up letter, and I admitted to, yes, that was mine.
And then after we provided screenshots of your own words, you thereafter ceased communicating with us, and we received a letter from Chairman Spotted Bird stating that he was directing you and Chairman Lamont with the Gaming Commission to not interact with the legislature, or answer any questions going forward. Have you corresponded or had verbal communication with Chairman Spotted Bird before he issued that subsequent letter stating that he was directing all communication to cease between the ACOA and the Gaming Commission and the legislature?
Yes, Chairman Spotted Bird told us not to talk about the open investigation because it was a matter between him and the NIGC.
Okay, so just kind of going back to one of the kind of establishing documents initially, there was a call, battle cry for transparency in 2020. And the, urge that it's what the KIC demands. But people believe that you transparency to other lateral branches of government, to the executive branch, or do you not believe in that? That's the transparency.
Not for an active investigation, and when the chairman of the tribe tells you not to talk about it because it's an active investigation, you follow the demand.
Did you, so you would be transparent were it not for Chairman Spotted Bird?
I remain transparent in every action that I do, yes.
Okay, so in terms of an active investigation, do you also believe that transparency is called for unless there's an active court case?
Sure.
Okay, so you published quite frequently about the ongoing court case involving Chairman Kamalti when I believe Joe Poe filed a CFR court case, and you posted quite abundantly about that on Facebook. So what differentiates you're stating that there needs to be transparency except for court cases, except for investigations, but suddenly, unless it encompasses yourself.
Was anyone told to not talk about it at that time? I don't believe there was.
Okay, so you have to be told not to talk about it before you want to talk about it.
If my boss tells me not to talk about something, I don't talk about something.
Okay.
Why would I question it?
Well, okay, at this KIC meeting in June, the special KIC meeting, there was a discussion about this, and you were asked directly about it in front of the KIC,
Right.
and you immediately deferred to Lawrence. So I guess my question is, in terms of the Final Casino Operations Authority, as its chairman, do you have no voice whenever you are otherwise directed by the chairman? You can't speak about anything.
As I previously stated, I was asked not to talk about an ongoing inquiry.
But you
And
just
that-
talked about it in that Facebook post in January 2025, where you're saying that you were found innocent. So when does that apply and when does it not?
Mr. Speaker, could the witness finish this question before we?
Finish his response.
Wait, yes, Mr. Graham, while you're kind of interjecting, I want to ask again. This question is about an active ongoing NIGC investigation. You are here representing Chairman McMahon as he's like the KCOA, or are you representing him in an individual?
To the questions.
Well, I'm going to establish it for the record. So
I told you before why I'm here.
well,
You subpoenaed Mr. McMahon as chairman of the KCO.
Okay, then
well, I'm going to ask questions when I feel
the questioning will come from the legislators to the testifier.
Okay, so let's be clear.
I would request that the witness be allowed to finish his answer before there's an interruption of his answer with another question. I think that's common courtesy.
Yes, please finish your response.
I don't remember the question now.
Okay,
It's been all over the place.
well, okay.
You were asking about transparency and yes, I believe we should be 100% transparent. But if the chairman of the tribe asks me not to speak about an ongoing investigation, then I'm not going to speak about that. So the comment, you know, I may have spoken out of turn. But if you're trying to establish that, well, I don't know what you're trying to establish. I mean, you grandstanded at KIC meeting. And we allowed you that opportunity. So.
Well, you didn't allow me the opportunity, the KIC allowed me the opportunity, which was chaired, the meeting was chaired by Simona Foreman, so let's be correct about that. In terms of the, the publication on January 2025. They've established, I think, that you saying that you may have spoken out of turn and spoken in contravention to Lawrence Spotted directive, not to share information. Was that the only time that you spoke on social media about the NIGC investigation?
I don't know.
Okay. You don't know.
I don't know.
Okay. Did you do it frequently enough where you don't know?
I don't know.
Okay. So let's take a look at the kind of, history and context and dive into that. So, Jason, if you could pull up, document number 9.
He's here.
Okay, so this is the letter of concern that sparked where we are here today. And so this is transmitted from the NIGC to Chairman Spotted Bird on November 2nd, 2023. In terms of kind of that text, I believe it's multiple pages. And then Jason, if you could maybe kind of just read along, but it identifies probable violation, KCOA board member payments. And it states, in the NIGC Compliance Division's view, the Powder Tribe of Oklahoma's misuse of net gaming revenue violates the Indian Gaming Regulatory Act, National Indian Gaming Commission regulations, and the tribe's gaming ordinance. This may result in the Compliance Division recommending the chairman issue a notice of violation and a civil fine by the NIGC chairman, not the tribe chairman. So just to establish any determination of fines or potential civil penalties for this is going to come in the NIGC, not internally within the tribe. As we kind of move over to page 2, we've got a pretty broad reconstruction of the violations that the NIGC documents. And then on page 3, we've got a nice little grid where it identifies Ms. Dunlap, Mr. Poe, Mr. McMahon, Dr. Kennedy, and Mr. Yeager within the kind of Volkswagen totals that are of potential concern and that may warrant, theoretically, as it stated earlier in the letter, a civil fine. It also mentions the travel and other expenses. And then a time period of response is laid out, as well as an itemized list on the final page 4 of 5, penultimate rather, but it's effectively the kind of final page in terms of substantive content. And in terms of other kind of sequence, it lays out the NIGC recommendations for avoiding enforcement action. Post-enforcement action would be potentially a fine. Correct me if I'm wrong, but obviously in the initial kind of outreach of NIGC, there is no indication that those KCOA board members would not consent, correct? That's correct. Okay. Moving on to document 10, Jason. We have the February 1st, 2024 letter. And this is from Lawrence back to Mr. Cunningham of the NIGC. In terms of this particular type of epistle, it is 5 pages, 7.5 pages and some. And this is what you responded to in the February 2nd, 2024 letter. Where you said, I am not repaying anything, correct?
I don't know.
We can revisit that later, but
Sure.
my understanding is that based upon, the content of that second 2024 letter, this is what you responded to. And I will stipulate that we can revisit that, just to clarify. And staged letter as well, if I'm incorrect, but the timing makes sense in terms of you sending out a letter on February 2nd stating that you're not going to repay anything. In terms of Lawrence's communication to Mr. Cunningham at the NIGC, he outlines kind of the provisions about the Fifth Amendment Charter and the Sixth Amendment Charter, which you would have been under the Sixth Amendment Charter during your time in the KCO Board of Trustees. On page 3, there is kind of clear delineation from Lawrence that says an express limitation on the number of KCO board meetings may be held annually as follows. Regular meetings of the board shall be limited to 12 monthly meetings, and special meetings shall be limited to 12 meetings per year as well. In terms of kind of the provisions there, at least from Lawrence's perspective, because he signed this in February 2024, it's pretty clear what the kind of outlines are. On page 4, in item 4, I believe it's item 3, 4, and 5. We have the delineation.
Wait a minute. Whoever's phone that was, can you silence it, please?
There's no recording allowed. Okay.
There is no recording allowed. Yes, please do not record. If you have anything recorded, please erase it. We will have a record of this meeting. We will publish a recording. If anyone needs, all the information.
So on page 4, we have enumerations of the amounts allowed in each annual budget during your time on board. In 2018, of course, it says $300 per meeting. And then in 2019, there was no annual budget approved for the Kyle Casino Operations Board of Trustees. Nor in 2020 was an annual budget approved as part of the budgetary process for the tribe. Do you agree that the allocation in the tribal budget are pursuant and consistent with the protocol and sort of process established by the Kiowa Constitution?
No, I think I made it very clear that I didn't agree with any of the correspondence that Lawrence was sending back to NIGC. Because nobody had asked for any documentation, evidence, or how the board was being run. One of the things that he didn't know about was the Iowa Business Committee meeting that took place on July 15th of 2015, wherein the Kiowa Business Committee voted to increase the KCOA stipend to $1,000 stipend per meeting. So that was passed in 2015. So when I say the numbers are not accurate, they're not accurate because nobody took the time to look at all the investigation, to look at all the documentation, to ask anybody what was going on.
Okay, so we're
So
talking
it goes back to due process and the lack thereof. So we can spend all day going back and forth about the NIGC letters, but I go back to the whole fact that due process was never afforded here. So
Well, you're getting your opportunity to tell your side of the story.
I gave my statement, which lined out everything, but you're still logging a dead horse here with all the letters back and forth with NIGC.
Okay, well, I'm gonna establish or those.
And I've established that
What the NIGC letters contain and what they conveyed.
what they contained, they were fed false information, they were fed misinformation. I've made that very clear.
Okay, so false information here, are you stating that it's false in 2019 and 2020 that a budget, annual budget of the tribe, are you stating it did encompass those
I don't know what the budget of the tribe should have come on. In 2018, I was brand new to the board. In 2017, our tribe had just adopted a new constitution. So the tribe was in its infancy with moving away from KBC to the four branches of government. So I don't think anybody knew what the heck they were doing.
Well, I'm glad you brought up that we were in a new constitution. So with respect to the roll call vote that you just cited in 2015, that was under the old constitution, correct? You have about.
The roll call vote.
You just held up and brandished a roll call vote. With from the Obama administration. And so my question is, that was under the old constitution, correct? Based upon the date.
Based upon the date, I don't know what it was under.
Okay. And then,
I was not involved in tribal politics at that time.
you know,
What's your point?
you know, when the old constitution was in effect versus the new constitution?
No,
Okay.
why would I know that?
General historical knowledge?
No, I didn't get involved in tribal politics until 2018.
Okay, well, the new constitution was ratified in April 2017. That's right. Yeah, it is fair. And so the document you're brandishing is the local constitution, but beyond that, in terms of that roll call vote, is there text in the vote that replaces text in the existing charter?
I don't have that information.
Okay, well, I can tell you, if there isn't, because it is a roll call vote with a motion. There's no legislation for the amendment to the existing charter at that time. So there was a vote on an idea with no supporting legislation. Do you think that takes effect?
I don't know how the operations work under the Cowboy Business Committee.
Okay.
There's a motion and a vote in subsequent pages. Now, I'm not a legal expert by any means, so you can make that assessment on your own after reviewing the information.
I'm just asking your opinion.
I don't have an
I mean, you're the one brandishing it.
You're asking me questions that I've already maintained that I don't know the answers to. When I came on the board, there was already an established compensation plan in place that stated that the board was compensated for quorum and non-quorum fees. The non-quorum fees included any time that the board met and conducted duties outside of the meetings. So when we met and talked to Hobart about getting the initial land, that was a non-quorum fee. When we went and talked to the bank to secure financing, that was a non-quorum fee. There's a lot of work that the board does outside of the special meetings and the meetings that you all attend. There's multiple things. And me now sitting in the role as chairman, I understand what Susan and Joe went through as far as bearing the burden of the board during that time. It's not just you come to a meeting once a month and that's it, you collect $4,000. No. You look at everything that this current board has done. We just built a new hotel in Hobart. That's doing wonderful. There's a lot of work that goes up into that. This is a part-time job for the board. This is not a full-time job. You all have a full-time job. So I'm sure you know your laws and everything to a T, right? You can tell me what Article 4 of the Constitution says?
I can dive into it with you, but.
Right, probably not. I'm just establishing a groundwork here that you're expecting somebody who's brand new to a board of trustees to know the rules inside and out, know the charter verbatim. And I'm saying that's not possible. When we hit the ground running, we hit the ground running. And in our orientation, where we're told how you're gonna be compensated, because you're gonna be asked to perform duties outside of the monthly meetings. Why would I question that? I said, okay, I'm gonna do it. I'm gonna go meet with Hobart town officials to see if we can secure the land. I'm gonna, perform all these different duties outside of the normal meetings. And I think that's what you're failing to understand with how this was set up. But once again, I didn't set up how the board was paid. I came in, I attended an orientation, it's delineated in the packet. This is how you're gonna be paid. Why would I question that? You're trying to dance around all these things where you should know better. Well, no, you don't. If you're told what to do, you're told what to do.
Do you believe that you should read your own KCOA charter? Once you become a,
I did read the charter, and as I referred to in my opening statement, our attorney, who was there at every meeting, used that last portion to justify the non-quorum fees. Now, if you want to find an answer why, you need to bring Tom Zenda in here and figure out why he counseled the board the way he did. Okay, I had no control over that. But he used the last bit of that section 13.15 to say, you guys are gonna perform trustee duties outside of the regular meetings, and you're gonna be compensated for that.
okay, I didn't. I can't remember. Do you believe that? As the new director. KCOA Iowa Casino. Board of Directors. Do you believe that you should read the KCOA charter?
Yeah, I never said you shouldn't read the KCOA charter. And I believe every board member has read the KCOA charter.
And within that charter, does it state? Compensation? Does it discuss compensation?
Yes, section 13.15 of the sixth amended charter for the time frame that we're discussing this letter of concern issue. It talks about compensation.
You know what it states?
Do you want me to read the whole statement or just the last part that the attorney used to justify?
I was just asking if you know what it states.
Yes,
Okay, and if you'd like to. We can point it out. Can we pull that up?
You want?
The charter, the Sixth Amendment charter.
Got it.
Page 3.
1 sec. You want the 2018 charter, correct?
No, that is what I'm looking at.
You wanted section 13?
The section that covers.
13.15 compensation.
Yeah. Well, did you want to maybe start with 1311 speaker?
Yes, 13.
Matt.
Okay. $13.50.
1315? You are, sir.
Okay, so this is the Sixth Amendment charter. Is this the charter? Which was which was law at the time that you joined the board?
Yes, the sixth amended charter.
Can you read out section 13.15?
The trustee shall be entitled to receive a fixed stipend as compensation per meeting as set in approved annual budget or budget modification. The per meeting stipends shall be for regular and special meetings of the board. The trustee shall be entitled to receive reimbursement for any reasonable expenses incurred in connection with the performance of the trustee's duties.
Are you familiar with the tribal budget, annual budget for that year?
Not without referring to documentation.
And we'll pull it.
We can go back to the February first letter on page 4.
Okay, yes,
Here's the budget.
Go back to the February 1st letter on page 4.
February 1st, on page 4. Could you give me the exhibit number? I got it right here, page 4. Got it, never mind. Come back.
I real back.
Speaker, yeah, also new point of order, Cole's, it's actually his hour.
Oh, yes, sorry for interrupting. No, so just speaker, you asked about kind of the budgets for those particular years. And we've got a handy sort of grid created by Lawrence, and that's been kind of the numbers that it stipulates and delineates from Lawrence into the year 2024. That in 2018, when Mr. McMahon joined the KCOA board, it was the annual budget set the meeting rate at $300 per meeting. And then in 2019, there was no allocation approved for the KCOA board in the annual budget. Others tried, was their allocation contained in the 2020 fiscal year budget approved by voters at the time. So given kind of the provision that we just read in section 13.15 of the charter, Mr. McMahon, are you stating that this is incorrect on our part?
I'm saying it's incorrect on anybody's part. We've got 4 legal opinions that state the KCOA charter does not require approval of the budget by the legislature. Consistent with the interpretation that the Constitution does not require the KCOA budget to be approved by the legislature, the KCOA charter does not require legislature approval for the KCOA budget. Instead, the KCOA charter makes it clear that the KCOA board has complete control over the management of all business operations, except those requiring legislature approval. The list of actions requiring legislature approval does not include passing a budget. So yes, it was intended by the chair people at the time in question of the letter of concern when I served on the board. I believe this was a point of clarity that they were all trying to get, considering that we were in the infancy stage of a brand new constitution. Whether or not the KCOA budget needed to be included on a tribal budget was undecided. Yet we have 4 legal opinions that say it should never be included on a tribal budget because it is a separate and autonomous entity of the tribe.
Okay, so it's an autonomous entity, so is it located within the executive branch or not?
I don't know.
You don't know?
No, I don't know.
As the chairman of the Cayuse Casino Board of Directors, you don't know whether you're an autonomous entity or whether or not you're located.
We were established as an autonomous entity, but as time has morphed, we've become a board underneath the executive branch. The executive branch has the power to create that.
So, okay, so you stated though that you're autonomous and that these legal opinions, did you pay for these legal opinions through the KCOA? The legal opinions you're saying.
Let's see. I did not pay for these legal opinions.
Did the KCOA pay for these?
The KCOA paid for legal opinions. Yes.
Okay. So given the assertion of autonomy there, that seems to operate in kind of direct conflict with taking orders from Chairman Spotted. So do you defer to Chairman Spotted, or do you, are you autonomous?
Depends on what time frame you're looking at.
Okay, during this period, were you autonomous?
During this period, I don't have an answer for that.
Okay.
I operate as a trustee, so I wasn't in a position of leadership or power to make those decisions.
So you weren't just familiar with the charter of the, or the Constitution? And where you.
I know at the time, we reported and worked directly with the chairman at the time.
Okay. And right now, are you autonomous or are you subject to the executive branch?
I think it's open for interpretation. I mean, we can spin around and go, but what's the point? Where are you trying to get to? I mean, surely there's a destination, right?
Well, you think that, okay. So, Mr. Graham. Again, are you here representing Mr. McMahon as an individual or in the capacity of?
And I'm not gonna answer.
Well, I'm going to continue asking that and you can.
It's the same answer. If you can't understand what I told you before, then I'm sorry.
Well,
Yeah, we mark past that and non-answer.
No is an answer.
Chairman McMahon, as the, do you believe that the KCOA Board of Directors has a fiduciary duty to try into its assets?
Yes, we have a fiduciary duty to grow the enterprise, generate income, and invest in drive.
Do you guys have a, meaning the board, does the board have a fiduciary duty, like a legal and ethical obligation to safeguard the assets of the tribe that are under your purview of the assets?
Yes,
Okay. And would a civil penalty enacted by the NIGC be an abrogation of that responsibility?
no,
So penalty that we would pay out of our assets, our gaming enterprise, that would not be something that the KCOA should protect against.
why don't you ask the people who created the policy?
Well, I'm asking you because you're the chairman.
I'm the chairman now.
Have you said that was the
You're
ground?
referring to issues.
No, so,
You're referring to issues back in 2018, 2019. I've already provided ample answers regarding that.
Okay, so right now, as established in the NIGC letters, there is the idea, at least the possibility of a civil penalty. Does the KCOA right now have an obligation to protect against a civil penalty or a financial finding?
It does, and we have.
Okay, so the NIGC has consistently stated that overpayments were issued, there has been no real deviation on their posture. So how are you protecting against a civil penalty right now, in that capacity?
Has the actions of the current board raised a letter of concern with the NIGC? You keep asking me about the letter of concern issue from 2018, 2019. I gave ample answer and response that I was not in a position of power or control. So the current board has not done anything wrong. The current board has thrived successfully. We've grown the enterprise. We amassed a lot of money for the tribe, which we just transferred over to the tribe. We built a brand new casino and used our capital assets to pay for it. That's a pretty good thing. I think in the business world, if anybody can come in and take a fledgling business and turn it around, pay off all the debts, build a brand new facility, use capital to pay for that, come out of that debt free, amass a savings account so that we can reinvest into future opportunities, one which you helped vote down. Well, that's a good thing. In the business world, we would be applause. But you're trying to paint this picture that, we amassed all this money and the KCOA is just holding on to it. That was not the case. As a fiduciary responsibility to grow that enterprise, that's what we were doing. Well, now we can't do that because we gave all that money back to the tribe and it's gonna be locked up. Nobody can use it unless the KIC votes on it. So I don't understand why we're still harping on old issues that I had no control over. Let's talk about current business, because I want to talk about the good things that this board has done and this board has accomplished. I can't answer any more questions about the letter of concern issue. I've gave my statement. I'm not going to go back and forth about, what this says and what we've already told you. What information the NIGC was provided was inaccurate. I can't correct that. I didn't provide that information. But when Chairman Spotterberg came to us and said, well, let's hear your side of the story, and we provided the information, he cleared us of any wrongdoing. Yet you're still harping on stuff that I had no control over. Can we move on to some actual business and get off of the letter of concern issue?
We'll direct the questions once again.
My apologies, Mike.
So you stated that you were not going to be able to answer any more questions about the NIGC letter of concern. Is that your refusal to?
It's not a refusal. I know what you're trying to do there. No, I said I've provided ample information. And I provided a very sound statement as far as what information I was privy to, what information I knew. So you have that information. I mean, unless we're gonna sit here all day and flog a dead horse, let's move on.
Why is it so troubling to you when you visit your own words? That seems to be a trigger point for you. Is that a trigger point?
It's not a trigger point for me.
Yeah, you just
It's
said.
not a trigger point. You keep trying to make these statements and they're not true. They're not true, Cole.
I'm asking you questions. Which part is not?
No, you keep asking about the letter of concern issue, an issue that I had zero control over. Okay, I had zero control over. I don't know how to make that point any more clear than I have read.
You have control right now as the chairman of the Casey Board of Directors, and you have control now.
I have control over a very successful board that has done really great things for this tribe. Yes.
And you have control over a matter that is still an active ongoing investigation under the NIGC.
I don't have any control over that, no. That communication is being directed between the NIGC and Chairman Spottenberg. The KCOA is not involved in any way, shape, or form in the active inquiry.
You don't have control over whether you make repayments to, as the NIGC has basically effectively directed the tribe to undertake.
Because they did not have all the information.
Okay.
So they issued letters based on the information that they received, which was again, not complete, not accurate.
So both the NIGC's letters are wrong, and also Chairman Spotted Bird's correspondence to you throughout 2024 is wrong.
His letter, whenever he cleared us after reviewing all of our evidence, is right.
Okay, what about the correspondence from April 2025 from the executive branch initiating or conveying to the NIGC that effort to resume clawbacks of those payments?
I am not aware of what money you're talking about, so you'll have to pull it up as an exhibit.
Okay. Jason, can you pull it up?
The NIGC's response to chairman's letter first, or do you just want Randy's letter?
Well, let's just go to item 11. We'll get to what I just referenced sequentially.
Yeah.
Beating a dead horse, quote unquote, but you'll just skip the rest in sequence. So, in terms of 11, we have another correspondence from Lawrence, and it delineates on March 12th, 2024. A follow-up response to Mr. Cunningham of the NIGC. And it states that the Gaming Commission is aware of the NIGC LOC and the tribe's response with a corrective action plan. In terms of the corrective action plan, delineated at that point, there was a provision containing comments of the overpayments issue. I don't see anything in there yet that would indicate that finding of any sense. Is that a fair assessment at that juncture in March of 2024?
Sure. But it was in May of 2024 when he sent his letter to the NIGC that cleared us any wrongdoing, correct?
It was in May. What we're gonna do there?
Okay, well, can we speed it up? I'd like to talk about other things except what I've already addressed in my opening statement.
Oh, well, by all means, you should want to talk about what you want to discuss, right, Chairman?
Well, I think we've pretty much covered the letter of concern issue. You keep going back and forth and I've already made my statement, so. We can harp on this issue all day long, but it's not gonna get us anywhere. You had other issues that you wanted me to talk about, and I'm ready to talk about those.
We're gonna dive into those.
I mean, I can just sit here and reread my statement.
If that's what they feel compelled to do, then you are by all means entitled to.
Well, again, let me restate for the record. I have already addressed a situation that I had zero control over as a trustee on the board 2018 to 2019.
So in terms of you having zero control, do you feel that the trustees on your board, like the director of Poppy, sorry, not the trustees on your board because they're now directors, but Director Hockney, do you feel that they don't have any control over anything?
No, I don't feel that way.
Okay, because your formulation is that you have no control over anything related to this because
No,
you were a trustee.
that's
That's
wrong.
what you said.
I said I had no control over a compensation plan I inherited when I was installed onto the board. A compensation plan of non-quorum and quorum fees that was already there. That was explained to me during my orientation, that that's how the board would be compensated. How many times do we have to go over this? I didn't control that. It was already in place. I didn't put it in place. You have to go back and ask the previous board members. Why is no one else here testifying that during that time frame? Why is it just me? I'm glad you think it's funny.
I don't think it's funny. I think it's interesting. I think it's a little bit ironic, but
Ironic how?
I wish you had some passion for safeguarding us against a civil penalty or a potential financial finding.
I don't have any control over that. And I do safeguard. I've safeguarded all of the KCOA money. And I took measures during this current board to amass, what, $50 million? And we just passed a second audit, a clean unmodified audit that found zero money missing. I'd say that's something to be pretty proud about.
Well, be proud, by all means.
I am proud of that.
No one's saying you can't be proud of that. In terms of your kind of dichotomy here, where this was a different board of trustees, this was a different entity from the board of directors now, you didn't have any control over it back then. So has Mr. Graham provided any legal advice to you, to the KCOA, about that investigation?
I'm gonna object that that is attorney-client privilege.
The fact of advice is not privilege. The advice itself would be. Whether or not advice has been given is not subject to a privilege. The advice itself would be subject to the privilege.
I didn't ask what the advice was, I just asked it occurred.
What was your question again?
So with respect to the dichotomy, as I understand it, that you're laying out, where you didn't have any control over events back in 2018, standard, and then now you do have control. because you're the
Let me clarify that because you're misconstruing my words. I said I had no control over the compensation that the board received. In reference to quorum and non-quorum fees.
Okay. In terms of original thematic dichotomy there. Has Mr. Graham provided you with any advisement on the NIGC investigation that encompasses prior board? Current. Like, has he currently or in the last 2 years provided you with advisement on that investigation from several years ago?
Mr. Grimm and Berwin Grimm, the firm, has advised the KCOA August 2022 and matters to current date.
Has he provided you though, have you discussed the NIGC investigation with him?
I've got other legal counsel for that.
So you have discussed the NIGC investigation with Mr. Grimm?
Mr. Grimm has had to look at the information to see if it was a conflict of interest. And once he identified that it would be a conflict of interest, he said he can't advise the board or me.
We can't advise the board.
He can't advise the board on letter of concern issue.
Okay, so then why is he here with you?
Because we're not here to just discuss the NIGC. The subpoena I received had 26 different items, right? 26 different items. And the NIGC letter of concern issue was one of 26. So I'm still waiting because it's 154 and we haven't addressed 2 through 26 yet. Because you're still harping on an issue that I've already made very clear I had no control over. So the other items that you wanted to talk about in the legislative subpoena, that's why Bill's here. Because he represented the board.
Great. In terms of moving on, let's take a look at item 12, Jason.
Right here.
Actually, there should be like a 15D. Can you go to that? Okay, so we can pull it up if we need to. But of course, earlier we referenced the April and March 2024 communications to you from Chairman Spotted Bird, where he specifically stated that he owed $32,100 for the calculations conducted by the executive branch at that time. And kind of went into deconstruction about why so the charter provisions of the 60-minute charter were violated. And then he asked you in April for a response. Because he hasn't received a response, the definitive response at that time. It is my understanding that in reference to, or in response to that, this meeting was convened on May 16th between the signatories who attended. So that would be former Vice Chairman David Zilli, Chairman Spotted Bird, you, Mr. McMahon, Joe Poe, Stephen Casella, Dr. Kennedy, and Luke Yates. Is that generally correct?
Yes, we had a meeting with the chairman. That is the meeting that I keep referencing, May 16th, 2024.
Okay. And in terms of the nature of that meeting, was that just an internal discussion among the folks here?
That, we've already talked about this. That meeting was him providing us the opportunity, after we had all pleaded for a proper due process, investigation or inquiry into this letter of concern issue. Because up until that point, nobody had all of the information. So within this meeting, we provided the binders, and you've got the binders in the legislative thumb drive that you've got all the information that we provided to Chairman Spotted Bird. Information that he and Jacob Sotai used to arrive at a conclusion that the non-quorum and quorum meeting fees were justified. And he issued a letter to the NIGC stating that very fact.
We'll get it there. So you'll like the next document,
Yeah.
but in terms of this particular meeting that everyone signed into, there are notes about case-related board members. I believe that's looks like report tutors, Tom Venda, a couple of other handwritten notes that are sort of difficult to read, at least for me. But in terms of kind of you really emphasizing into due process. So, I mean, typically due process, at least from my understanding, includes an equitable kind of hearing of perspectives or sides. So the folks who documented or provided source documentation for the concerns that spurred the investigation, they were not present, correct? That's what's meeting?
That is correct.
Okay.
So we don't have the initial response that was sent from the that spawned this investigation.
Okay, so in terms of the attendees, it was you as the chairman of the KCOA, the former trustees, and Chairman Spotted Bird and Vice Chairman Zimtai. How does that reflect due process in terms of fairness? It sounds like it was only one side of this informal hearing, let's call it.
How was that due process? We were allowed to tell Chairman our side of the story so that he could get his facts straight.
Well, it sounds like as a political person in the tribe who has influence as leader from the KCOA, you have this meeting and prevailed upon him to change his mind. But I don't see that there is it seems to me you kind of emphasize the one-sidedness of this, framing, but this was the opportunity where you have a chance, to be.
How are you supposed to present witnesses that you don't know?
So did you present? Anyone of that nature?
Someone's in that didn't respond.
Okay. In terms of the next letter, Jason, let's move on to item 12. This is where you're gonna like this, Chairman McMahon, so I'm gonna foreground that June 27th, 2024 board times.
In an effort of fairness, is there another legislator who would like to speak for a moment? Or possibly yield comments to Legislator DeLong? I will. Thank you, Legislator.
Thank you, Legislator Wolf. Thank you, Soldier. So now we have the June 27th correspondence from 2024. I know this is going to be your favorite part of the afternoon, Chairman McMahon. So we have here a 2-page letter sent to Tom Cunningham of the NIGC. It is much less expansive than the 5-page letters that were transmitted to you and to the board of trustees. But essentially, Mr. Stolberg recaps kind of that May 16th meeting among yourself and him. And he interestingly kind of synopsizes some allegations about a former casino in PLD, and then talks about a quote-unquote internal investigation that he does not define. He states kind of that his synopsis was that the payments made to KCOA board members for that extra work to carry out the management and development of the Kiowa casinos were in the best interest of the tribal classified as meeting stipends. Those payments were authorized to valid work performed in addition to board meetings in support of the Kiowa casinos. And then it also says there will be no action taken collect any stipends paid to these former KCOA board members. Unfortunately, we are here a year later because the final determination, of course, of whether or not an investigation is complete and the findings of fact are the discussion of the chairman on the NIGC, not of our tribe internally. But of course, this is kind of the letter that you have been referencing throughout the afternoon. I believe you said it was released in May, but of course the meeting was in May and this was released in June. I'll give you the opportunity to, note anything or highlight anything. Okay.
Letter speaks for itself.
Okay, this will all be available on our legislative homepage, I believe it is now. And so moving on to item 13. Okay, we have a response from the NIGC dated March 11th, 2025. The first couple of pages are just synopses of what has happened to date, particularly the chairman of the tribe sending out kind of responses to their letter of concern, their delineation of intent to develop corrective action plans. And also kind of just provides historical context of the last board meeting for the attendees here, without getting too much into the preamble. On page 3, Jason, here we go. You kind of penultimate few lines state the tribe's third follow-up response letter incorrectly states the timing and sources of the information provided to the NIGC. Of course, in the June 2024 letter, that looks like Chairman Spotterberg ran with kind of your account that this was the malfeasance and the nefarious work a former disgruntled United employee. The NIGC here states the information regarding these stipends was received from multiple sources from 2019 through 2025. And to revisit kind of the point, that COOGM was terminated in 2022 or 2023, correct?
I don't have that information in front of me right now. He was terminated.
We, I believe, agreed, correct me if I'm wrong, that he was terminated after Chairman Boniford was elected into the chairmanship, correct?
Yes, he was terminated after the election.
Okay, so that would have been 2022. That's just historical data points. And the NIGC expressly states here that the information sourcing for these components was received from multiple sources from 2019 through 2021. Moving on to page 4. In the same document.
Should be. Okay, just refreshed.
At this time, the NIGC remains concerned about the issues raised in the LOC, and our investigation is ongoing. In an effort to resolve concerns, the NIGC requests the tribes provide a copy of documents identified in the attached list. So, just for the record, and you're going to get impatient probably with me here potentially, but I'm just establishing for the record that you have received no other word from the NIGC signaling conclusion of the investigation.
I'm seeing a lot of these documents for the first time today. The IGC documentation does not go to those that were made and nobody concerned.
Okay. But just to be clear, you don't have any reason to believe since the date of March 2025 that the investigation is concluded. It's not a trick question. It's really.
I didn't say that the investigation was concluded.
I'm not saying that you did. I'm just saying. Correct. You have not received anything to signal that.
That is a correct statement.
Okay. Moving on to letter 4. 14.
That letter says we put the resident at 24, not 25.
To refresh, Bill, it is 25.
We can go back to the cover page.
I'm going, trying to make it go back. Maybe. Just a typo.
Subsequent pay in the state.
So even the NIGC can't get the facts straight.
Very well. 14.
The very beginning of that letter, I'm just making a point. It does state 2025.
Okay, so this is a correspondence from Attorney General of our college job, Brad Number, dated April 10th, 2025. Jason, if you want to scroll down a little bit. He establishes Mr. Wheeler. Of course, Mr. Wheeler is, as we all know, of the NIGC. I have been directed by Chairman Lawrence Boniford to prepare and submit a response to your letter of March 11th, 2025, on behalf of Penny McCall Tribe. If you take a look down at each tab there, after having had an opportunity to review the facts, the documented history of this matter, and conduct an independent investigation, I agree to resume the course of action agreed to between the tribe and the NIGC and attempt to collect the overpaid stipend funds from each board member, Dunlap, Kennedy, McMahon, Pelham, and Yegu, against whom the recovery was previously sought. In this regard, the chairman and I will immediately resume communication with each commissioner along with KCOA and KDC to resume attempts to recover the overpayments received by each member previously noted. I have addressed the remaining document requests in order and supply with you as many as I can locate. We'll just put a nemesis at that point. Have you received communication from the executive branch that efforts to recoup those, I'll give you the word alleged overpayments, have resumed?
I received no communication from the executive branch regarding alleged overpayments.
So you have not received any indication from the executive branch that efforts to claw back those funds has been reinitiated.
That is correct.
Okay. Does it surprise you that the executive branch is communicating to the NIGC that efforts to resume clawbacks have initiated?
It neither surprises or. No.
Okay, so per Randall Holmberg's articulation here, it looks like. Chairman Spotted Bird has continued evolving in his position about whether or not those, you and Mr. Oh, Ms. Dunlap, Mr. Yegu, and Dr. Kennedy are gonna have to pay back those alleged overpayments. As we can see from Attorney General Holmberg, he's stating that he's writing on behalf of the chairman of the tribe and that he has agreeing to initiate clawback attempts. So do you feel that the chairman's position is wrong and this is delineated in this letter?
Yes, I don't think Randall has all of the information. And I think there's a lot of information. Once again, Mr. Humberg did not interview any witnesses. He took all the information that was fed to NIGC that was full of inaccuracies. And yeah, I think once again, he has not looked at the full case.
Well,
He has not reviewed testimony, he has not interviewed witnesses, he didn't interview any of us, so I don't know how he can come to this conclusion without having all the facts.
has Lawrence been privy to the full scope of facts?
Well, I know Randy has that same thumb drive that your attorney has.
Well, that's fine. So my question is, Jason, can we go back to the first page of this? He says, I have been directed by Chairman Warren Spotted. So Mr. Holmberg is not acting independently or autonomously. So it seems that Chairman Spotted has the full scope of facts, as you just alluded to, and has amended his position again, where he was directing initiation of clawbacks on those other candidates.
Okay, well, I've only seen this letter yesterday.
Okay. So in terms of kind of your perspective, like you can correct me if I'm wrong in this characterization, but it seems kind of you were leaning into the chairman's final determination had been rendered in the June 2024 letter, where he indicates that his no payments are going to be issued. And so it seems that that's not actually his final determination, because there's Mr. Holmberg stating that he's been directed by the chairman to resume clawback. So is Mr. Spotted more current final determination as reliable as the June 2024 determination?
That's a question for Mr. Spotted.
Well, I'm asking you if it's reliable because.
That's a question for Mr. Spotted.
Okay, so it could be reliable.
That's a question for Mr. Spotted.
Interesting. We have to defer to the lengths in terms of just the general kind of administrations earlier.
It's not my investigation.
Okay, so the investigation theoretically could still be reliable if it determines that you owe money back.
That's a question for Mr. Spotted.
Okay. Will you pay back money that directed to you by Mr. Spotted?
That's a question for Mr.
You can't say whether you would cooperate with the director?
No, I would say sue me in court.
Okay, so would it take a suit to compel you to pay back money that Mr. Spotted finds that you owe it
If
back?
that's the only way that we can get due process.
Did you not have due process in the May 2024 meeting?
There's not enough. I mean, you're saying that we need to call the side that brought in the thing, so let's bring in everybody. let's bring in everybody, let's get testimony for everybody.
Okay, so you would not pay back money without court enforcement if Chairman Fodder finds that you.
I'm not gonna answer that question.
Why can't you answer that question?
I'm not gonna answer that question.
Okay.
Mark that as a no answer.
No, that was an answer. An answer that I'm not gonna answer that question.
Would you defy an order by Chairman Fodder to pay that money?
I would not fight war.
Okay, it doesn't have to be a court order.
Yeah.
We're going to make a motion that we recess for 10 minutes to give everyone a little bit of a break.
I'm thinking it.
We have a motion and a second. To recess for 10 minutes. All in favor, say aye.
Aye.
All opposed? Any abstentions? We are recessed. Back in session.
Mr. Speaker, I'd like to invite the answer, because I don't want you guys trying to hold me in contempt of not answering for that last question, if I may.
Last question.
What was the last one?
Would I repay? I'll make that determination after the NIGC comes back with their final conclusion, so that's my answer for the item.
Thank you. And at this time, I'll turn it over to legislator.
Thank you. Yes, legislator, Tauti and Belong, yielding me some time. I just have a couple of follow-up questions, Mr. McMahon. So you had previously served 2018, you were a trustee for the KCOA. And you had resigned, what year, what time did you resign? What date do you recall? I just don't have it in front of me.
Yeah, no, it's I made a note of this problem. In January 2020, mine, Joe Poe's and Jim Kennedy's gaming licenses were ordered suspended by Chairman Kamalti.
And for what reason did those, did he give you a reason at that time?
It was in response to, it was retaliatory because we sued them in the CFR court. So we went for a long period. And just no activity, no contact with Chairman Kamalti. We weren't technically fired or removed, but our licenses were suspended for a hearing at the gaming commission. And then finally, we had a hearing at the gaming commission. And there was never a determination issued post that. And so I wrote a resignation letter basically in January of 2020.
Following that gaming commission hearing.
Yeah, I mean, I guess technically I was probably already fired, but I didn't.
Nothing official had come out.
Nothing official.
So you resigned following that.
Right, I just.
No contact, no communication.
Right.
Just gonna go ahead
It
and
was
resign.
it was a dead board at that time.
My next question, and I'm gonna move on to other issues. It revolves the recent firing of Steve O'Banion from the I believe he was the COO, is that correct? CFO.
Yes.
Steve O'Banion was let go from the Kiowa Casino Operating Authority. Can you elaborate on give us some idea about why that decision was made?
You know, when we hired a CEO to oversee day-to-day operations, it's the CEO and the HR director's job to perform assessment evaluations. And in the course of performing that, you know, the other thing is, as a new CEO, he needs to know where all the money's at.
Mhm.
And at that time, we had some old accounting software. And I think, I don't want to misstate anything, so Andrew wants to get this information. But after a thorough assessment, Bob reported back to the board and said, you know, basically, I'm giving Steve a vote of no confidence. His gap practices are not up to standard. We requested, you know, a lot of financial reports, and he wasn't forthcoming with a lot of that information. And I think, Speaker, if you remember, we talked and had a conversation at the Joan Jett concert. And we talked about the problems that we were having with the CFO and trying to figure out where all the money was. There were a lot of different practices that Bob didn't agree with, and once he brought those issues to the board, you know, we made the determination that that was not the way we want our money to be handled.
Okay. So it was, Jason, if you have that document up, we just kind of want to ask, was one of the, we want to ask what the reasoning was. Maybe it was a decision of the KCA board, or who made the decision to, I think we opened up 120 certificates of deposit all across the country with the tribe's money. Are you aware of that?
Yeah, that was one of the things that Bob uncovered, is that Steve distributed the money into sweep accounts. And the reason he did so many $250,000 sweep accounts is so that the money would be protected. FDIC insures up to $250,000. And so that was his reasoning. It's not best practice, but it's not a bad practice. We were still accruing interest at a rate of about 3%. I believe your financial expert is now looking at a potential 4% with that money. But it was how long it took Bob to find out that information. As CFO, he reported to the CEO, but they should have been working hand in hand. And the fact that he was not forthcoming with a lot of the financials. And those were some of the reasons that he put Steve on a performance improvement plan. And the board had made several recommendations through Bob. You know, we wanted to upgrade the accounting system. That's what you and I talked about, Mike. And, you know, we were implementing that. And then throughout the implementation, we discovered that Steve, who was in charge of the procurement process for that software, did not purchase a key component, which was the departmental budget component. And that was one of the demands of the board, so that we would have an accurate representation departmentally, because we weren't comfortable with the way the departmental budgets were being managed at the casino side. We wanted to streamline operations, and so that was one of the selling points for the new Sage software. But Steve failed to buy that portion. I don't know why. So that was kind of another ding against him. So those were some of the factors, and so with, you know, thoughtful consideration of his contract, we voted not to renew his contract in June. So
I think that for the legislative body, often it's been a question of ours, not, that was our frustration since I've been a member of the legislature, is not getting accurate reports. Or being able to decipher how much money the tribe actually has available to it. And it's been an ongoing discussion for a couple of years now within so I guess moving forward, I'd like to see more transparency, give us the real numbers. Who's the CFO?
We outsourced, instead of hiring a CFO, we outsourced to a CPA group, REDW. Figured that having an outside entity overseeing that, you know, they're gonna be unbiased. They're gonna provide us the reports when we want, how we want them. And just for clarification, we always knew where the money was and how much money we had. It's just whenever it was presented to the board on the reports, there'd be lines for miscellaneous and stuff like that, and when we'd ask for explanation.
Just clarification.
Yeah, it was, you should never have so many miscellaneous lines on the budget.
Yeah, I think that was actually my next question was, would you expand upon that? You know, I think it's expenditure reports that were made available to us by the KCOA, including without limitation, itemized expenses and miscellaneous expenses. We were kind of just wondering what those costs were.
Right.
Would you elaborate on that? What your understanding is, what are expenses and then miscellaneous expenses?
Well, yeah, I wish I could, because those were actually questions that we would consistently ask Steve, you know. Detail this out, and he would just kind of hem-haw around about different things. Well, you know, we had to move this money around, or we had this deviance over here, variance over here. So there was never any clarification. And I know it was a huge frustration point with Bob, who worked with him on the daily. Because Bob was like, look, I have to provide accurate reports to the board, and I can't do that, so you're preventing me from doing my job. So, yeah, there were just a lot of factors. The reason we didn't terminate him is because right after the election, he and John Peters renegotiated these pretty egregious employment contracts. And so even if he was fired for cause, if we found out that he stole money, walked out the back door, we would still have to buy out his contract. And we looked at, you know, legal mechanisms to get out of that, and in the end, it saved the tribe money just to pay out his contract, but to put him on a leave of absence. Since we were only at I think it was 2 or 3 months that we had to buy out.
That's all my questions at this time. Thank you.
Thank you.
Okay, excuse me. And at this time, I'll turn it back over to Legislator DeLong.
Thank you, Speaker. So Mr. Bengen, while we're on the topic, did he make investment decisions solely by himself? Or did he integrate in perspectives of the board? What was the protocol there?
We would have liked him to integrate with the board. We gave him several different investment options. And he explored several options that were presented to him by the board. But it seemed like they would always come back with, well, you know, this investment company doesn't want to do it with tribe because they wanted a limited way from sovereignty. So it seemed like there were always excuses given. But, you know, as the CFO, he is entrusted to do that investment for. That's not a board responsibility. So
When, I guess at one point, when the time general qualified. You're mentioning there was kind of excuses, kind of what I'm interpreting in your words. I'm not saying you're saying this, but a general sort of reluctance or kind of non-participation element from them. When did that begin?
we started questioning things. I think it was around, don't quote me on this, but around August of 2024. So I think the Joe Chet concert was September of 2024, and that's when I ran into Peter Primus there. We had a conversation about ongoing concerns that we had with, you know, where the money was, where it was sitting, where it was being invested and all that. And I wanted to reconvene with the executive and the legislative body, because at that time we were amassing a large quantity of money. And we wanted to look at what that distribution would look like for FY 26. You know, we wanted to look at areas of different possibilities, so we wanted it to be a collaborative effort. And I think I looked for the email that I sent Mike, I could not find it, but that just didn't, we never had that conversation. But we did meet with the executive branch, and that's whenever we increased from 6 to 9 million for FY 26.
You would definitely remember when Joan Jett was, right? But
Only because I looked it up last night.
oh, really? Are you going to do a concert for her?
If she comes back, I probably would.
in terms of, kind of this general domain of topics. With respect to certificates of deposit that legislator Weton was asked about. Were those readily accessible for operations over CapEx?
I believe they were, but that would be a CFO question.
Okay. And not one you discussed with Steve or, I'm sorry, was the gentleman's name Kevin Holston, was that it? So just clarifying, you haven't discussed kind of the accessibility.
No, we haven't talked.
Okay. In terms, documents, Jason. If you talk about that.
Yes.
We're gonna, just.
Speaker man, I left my binder.
Thanks, sir. Let's take a look at item 25. This is a layout provided, I believe, by the executive branch. Delineating all of the 15 memberships from August 2023 to 1/2025. We actually asked for more comprehensive, kind of, we get section, but this I believe is the most current, on page 3. Can you tell us what factors into the determination of how disbursements are made according to this grid? Like what variables go into the consideration of who gets what amount?
Typically, if a sponsorship came through directly to the board would defer that back to the chairman. And then if the chairman wanted to move forward with a sponsorship, then we would discuss that with our marketing team to see what would be the ROI for these type of sponsorships. Typically, we would, post signage, just, advertising the casino. So there was always some type of ROI in the majority of these. Some of these were just requests from the executive branch. For example, the Washington Trust Board, the Veterans Association. So.
Is there any regulatory written protocol that sort of deconstructs how those determinations are made?
There is now, there's a sponsorship act.
Okay. In terms of that, I'll tee up my next question, which is, September 25 meeting. A few weeks ago, was an interview with Casey Report. I believe, legislator Todd raised kind of the question in the past. It was heard by Texo about sponsorships particularly. And then, if I think on that, we mentioned that you could not be able, the board, to kind of approve that or, go with that because of the sponsorship act. Is that correct?
Yes, once we learned of the sponsorship act, we didn't give any sponsorships out.
Okay, when did you learn of the sponsorship act?
Oh gosh, it was recent.
Okay. I asked because legislator Weton, okay, subsidies the original sponsor and the sponsor for amendments. And so that will be the first amendment to the most recent amendment to the sponsorship act was passed by the legislature in August 2024. And kind of the penultimate item up in the bottom, we can see sponsorship American Expo, $10,000, Kyle tried directly from China chairman, and that I believe is seeded in October 2024. So after the sponsorship act is passed, and we have this disbursement. So based upon kind of the knowledge that was passed, in August of 2024, is if you're understanding that the kind of dissemination or transmission of money would be in violation of that act in October of 2024.
I can't answer to specific timeframes. When was the sponsorship act passed?
The latest amendment was passed in August of 2024, so 2 months before the last expo.
But I'm trying to remember whenever we were informed of that. I don't remember when we were informed of that. But as soon as we were informed, then we sought the sponsorship, so that we would be in compliance.
How were you informed of it?
I think Lawrence gave us a copy of it.
Okay, so that was,
It was recent.
okay. Because my other question is, let's see. March 19, 2025. We got a $100,000 disbursement. On the list, March 19, 2025, $100,000 disbursement to Rainy Mountain Church. And of course, I think we all collectively want to support kind of the rebuilding effort. But you were saying at that time, you were not aware of the sponsorship act.
Most likely.
Okay. But can you say that you can't say definitively or not?
I cannot say anything. I would if I could.
Um,
And Arthur doesn't remember either.
there are limitations placed in that act specifically for churches. There's a process and protocol, so $100,000 is a pretty big disbursement to be outside the scope of that particular standard law. So I think that sort of just raises kind of the general question as well about sound like you depend on laws to provide context for laws that he feels are applicable to the case, right? That's kind of how you take the rest of things like the question.
In this situation, yes, we received a sponsorship act copy from, I believe it was the executive branch.
Okay.
Shouldn't that have come from you all though?
In terms of
Whenever that law is passed, shouldn't have been sold to us.
it was transmitted to Lawrence, and so I'm trying to figure out where the commission gap occurred. Because whenever we pass a law, it has to be signed actually by Lawrence, unless it's, right, and so we always send over the we probably go over our signatures and finalize copy. And so I'm just identifying where the sort of gap occurred in this kind of context. And we talked about that, I think, a little bit.
I think people would try long enough to know that there's a lot of communication gaps.
But we've identified one together, so. In terms of kind of the other elements, you're stating that you would have kind of learned about this after 2025, right? You would have learned probably that in 2025, I would be that data, is that right?
Probably not.
Okay. In terms of kind of other components, we're gonna stick around. Probably going to be more things that I why or subject matter discourse. But one component, other question, it's just big legislative times currently. But I previously asked questions about the timeline of your exit from the prior board. And so, was your gaming license revoked at any point prior to your exit from the board of trustees?
For the first time?
Yeah.
No, it wasn't revoked and it was suspended. I don't recall it ever being revoked.
Okay. That. Reason if you could pull 70 up. I believe that the digital file is the working file that if you're happy to have, I'm happy to give you my copy. So we posted this on social media in 2020, I believe. And so, I'm just trying to ascertain the difference between a revocation and a suspension, because it looks like, from what I can tell, the gaming commission back then issued, it says notice of revocation, so.
Okay, so it was revoked.
Okay. And then you were on board until October of 2020 and sort of nebulous no man's land, correct? Is that right? I wasn't there, correct, kind of the period after that revocation.
No,
Okay. I believe, if I'm correct, just to establish the timeline. We originally had an appeal hearing in March, and then they moved that back to July. And then you didn't hear anything from them for a couple, is that correct?
yeah, and I actually did find it in my timeline here, it was revoked on January 2020.
Okay. And then on 70 G, Jason, can you pull that up?
July 7th, 2020 is when we had our
Appeal hearing.
hearings at the gaming commission, yes.
Okay. And then this is another social media post from the phone. And you are, I believe, writing to Chairman Kamalti, and if my understanding is correct, there was also a copy from Jim Poe that had the same text that was sent to Chairman Kamalti, but you guys refer to yourselves as former KCO board members. Is that correct about that?
That is correct, yeah.
Okay. In terms of other questions. Jason, you can talk to. Item 20. I'm probably environmental. Page looking for is number 1, that is not included in the middle one. There's about a couple sheets. And then the first page with a grid on it is what was being done.
My Zoom unexpectedly closed, I don't know why. I'm back in. If someone could let me in here. Yeah.
Right. Yeah, right. The first grid. Here. Like the actual budgetary grid. The big one. Yeah. Jason, I think you know, the part I'm looking at, which is police zero forward meeting fees. And it is about 7 items up from the bottom. We have that. You see? And so this is the budget from fiscal year 2018-2019. It looks to me like it says in the annual budget, $300 for each trustee, maximum 20 funds. Just noting that for the record. And then, so we're gonna hop stop around to a couple of different documents. That'll be 21AA and 21C.
21A.
21AA. Both after Z.
The coming right up.
Okay, so might be easier to look at the screen, Jason, if you can enlarge it. So this is an email from Joe Poe to Gloria Mystic. They gave you Jim Kennedy, Don Peters, or LCC. And it says from Joe's, from Gloria, I spoke with Richard about the board budget for fiscal year 2020. Given the activity we are going to pursue this next fiscal year, we wanted to run these numbers out for review. Monthly budget, 2 times $1,000 for physical foreign meeting fee, 4 times $500 for a non-foreign meeting for board conference call, $500 for travel mileage, and for 5 board members, kind of this for the construction. So was it standard operating procedure for the board itself, just to kind of throw out these numbers in terms of discussing and then collectively assenting, or how did that work? Because I know we talked about sort of, you mentioned the historical precedent of that being in place, but it seems, at least from this kind of communication, that there was at least some sort of collective working towards a consensus, if that makes sense. Is that a fair characterization?
Because before that, it was $1,000 for the non. Joe actually lowered the price. Or lowered the amount.
I'm more interested kind of in the process, so Joe lowered
The process was in place before I got on the board, and while I was on the board, it was $1,000 for. Forum, $500 for my board, $1,000. It was $1,000 for both, and Joe lowered it to $500 for non-board.
And it seems like the process was sort of him floating this out there, and you guys collectively discussing or assenting to it, at least to some degree. Is that accurate?
I believe this is probably when Robert Little was trying to put the tribal budget for the KCOA meeting fees on the tribal budget. And they were in these discussions about that. And that's what prompted like the climbers and winners. Legal opinions about non-including. So
obviously you have, I would guess, the most direct knowledge here since you were there during this time. So one of the questions that this just sort of organically raises is that it says $500 for conference call. Was there like a minimum time amount that had to be in place before that $500 was triggered, or how did that work? Like the conference calls?
it was for performing duties as a trustee.
Right, but I'm just asking about, it seems like you're kind of mentioning the evolution, and so Joe posits this out. And is there any sort of like the conference call has to last 30 minutes to be $500.
What you see is the resolution. That is,
Okay. So it sounds like there's no minimum for the $500 form. In terms of non-farm versus foreign, I know we dived into non-farm components a little bit earlier, but just for kind of the purposes of clarification, if you went to a community meeting or to the KFC meeting, did you guys bill or get paid for that one? Like, this one.
yes.
Okay. In terms of talking to prospective board members, would you get paid for that one?
Yes, this board business.
Okay. So how did you approach it? Like the challenge, I guess, because I know in the bylaws, and I will stipulate that, you know, you can object to them, but this would be reasonable in terms of stuff. But, there's a, chain sequence, and, I believe Joe is emailing to talk to Sean about potentially coming up with, that Sean's been, kind of floated a couple of different times. So in terms of that, how do you approach that when the chairman is kind of the tribe has the legal constitutionally to nominate someone, and then the legislature obviously has confirmation authority. So did you guys see any sort of concrete responsibility outlined for you to interview prospective people, or what sort of spurred you taking on that role?
You would have to have Joe Pro about that. That was funny. That's going way too far back for me. Spot.
Do you presently interview prospective nominees to the board?
Not anymore, not since Alina signed my name.
Well, we know Anita's very assertive, so. That's one of the things I love best about her. Do you think we can go to 21 feet?
21 what? You.
Just to put it into perspective, whenever I was approached to join the board in 2018, I was approached Chairman Dunlap. And I met with Chairman Dunlap and Joe Pro, and they vetted the qualifications, and then they presented me to Chairman Paulson.
And you recall being seated with Dunlap and Cohen kind of after your onboarding?
I was seated on my first day. That was a memorable day.
Where did you pay for the seating?
It was a non-forum meeting. It was an actual meeting orientation and then say.
In terms of this particular kind of missive, I guess my question is pretty similar to the last one, but it seems, like Mr. Post here is stating, we will go ahead and continue to apply the non-forum at $500. And he constructs down thread, but you're kind of chiming in with it looks fine to me. So with the prior, where he's loading it out to other folks, it seems like there was at least a solicitation of agreement or like collective, this looks okay. Is that how it was approached?
To lower from 1,000 to 500, it's at least $1,000 per.
Okay, yeah, in terms of, it's a nice one, I want to. So obviously we got, missed out on to gain $500, $500 on the side. We would move down a little bit further. But just kind of in general, But it looks like there was at least some move towards collecting, you know, looks really like you guys are working to this together. Is that fair or accurate assessment?
I wouldn't kind of as a fair assessment. I would stop again and ask for my opinion about lowering from 1,500.
Well, it says we will continue with the non-one, so, I'm curious about kind of the other information, in that. Jason, if you wanna go to the 21,
21
yeah. This is from Susan Dunlap. This is 2018. So she's kind of you know, giving a synopsis of her dinner with Jim Laporte and William Mystic. And then she talks about her conversation that she had with the PCA board, which would have been on board at that time. And so she says in discussing the transition, the board agreed with Jim and Gloria that was chairman, which was seeing day-to-day oversight, at least for the interim. So she is moving into what role at that point, you know?
COO slash ED.
But it's COO/GM, that's an office of the board, correct? Okay. In terms of the sixth amended charter, there is a prohibition on board members serving in office capacity. Were you familiar with that provision?
I am, and that's why Tom provided an opinion that this would be doable considering extenuating circumstances.
Okay,
So we can't just leave the ship without a captain at the helm.
so to the best of your kind of assessment, again, it's the best of your assessment, I'm not expecting to speak to the board at that time, since you were trustee, not the chair. But to the best of your assessment, with Tom's feedback there, the kind of determination was extenuating circumstances warranted, kind of conveniently neglecting a certain provision in the charter, is that correct?
No, that's not correct. That would be characterized immediately neglecting. I would say the board was facing extenuating circumstances.
Okay.
And they needed a leadership person in that role. So the chairperson, the chairwoman at the time, and the vice chair decided that they would take on the role. So,
Okay, but it's charter, just put it in.
I understand what the sixth charter says, but when you have a legal opinion from the case or a legal counsel who says, yes, go ahead and do this. What do? Do you leave the organization without somebody leading it and money can go out the door? Or do you put somebody in that's gonna oversee, maintain operations? And I might add that they maintained operations and still accrued revenue during that time. Now, whether that was legal per the charter, you know, I can't attest to that, but again, legal counsel approved it.
See, whether, I'm just gonna go back to make sure I'm correct, whether it was legal for the charter, you can't attest to that.
I went with, well, I think the board went with the legal opinion that was provided by the legal counsel. Who said it's okay to do this as an interim.
When did Tom's time with the board conclude? This is something when you,
I don't remember when his time concluded, no.
do you recall if he was still in place when he left or vice versa?
No, I never recall.
Let me take a look at 21 Y. 21 B. Definitely move on to 21 BB. And while we're setting that up. Was there any? Just based upon kind of some of the information you just digested, was there? You mentioned this was calculated and said lower than the don't not part of the bond, but if we, so was there ever any limitation delineated by the KCA board at that time? On how many conference calls or how many meetings per bond could be, you know, could be accessed or something, could be submitted for concept. Okay. In terms of this, so my question here is, you are getting a $500 non-foreign fee, kind of consistent with the SOP standard operating procedure that we just sort of went through. In terms of kind of the elements you mentioned, kind of visiting all these properties, and so I guess the question is, for the protocol that was in place at that time, just kind of like taking a bird's eye view. It looks like was primarily oriented around self-reporting, but that there was not really a documentation expectation from whoever was in charge of developing the protocol. Is that correct?
Could you reframe your question, a documentation process?
Right.
So what is the documentation?
Right, but so in an event like this, for example, you know, internally, a lot of providers will hire, right? MapQuest, the routes that you took, and then, you know, the dollar and then the mileage, or kind of just sign-in sheets or something of that. Was that ever element that was required by the methodologies processing or developing each time of this sort of stuff?
The process was providing, describing the board business, the trustee business, so to speak. And I think.
Okay. So, standard operating procedure was just to send an email saying, hey, I did this today, and this was the non-format that we or the work that I looked at for this.
That's the way it was not to do.
Okay. Speaker, make a motion that the assessor.
Okay, before that, yeah, one question, when the fees were lowered from 1,000 to 500, your other meetings are worth 1,000. You believe that was a fair amount per meeting?
The $1,000 per meeting,
Yes.
I didn't argue with that,
Was there a limit on how many meetings you had?
not to my knowledge, no. I think it was what was in the charter, but a lot of the reimbursements were for trustees performing duties outside of the meetings, like the monthly meetings that you all attend. For example, whenever I was scouting different offices that can host both the CADC's office, the executive branch, and potentially KCOA. That's time I took off of work, using PTO, using gas, to go to various locations to try and find a location that would be best suited for the trial. So, and that was if I remember.
Thank you, and was that a motion?
I second it.
Okay, we have a motion and a second to recess for in 15 minutes. All in favor, say aye.
Aye.
Any opposed? Any abstentions? We are recessed. And at this time,
Speaker, I think we can like to recognize Richard McMahon, chairman of the KCWA, for a closing statement. Maybe we can move that 5 minutes.
yes, it's Mr. McMahon.
Thank you, I appreciate that. We've spent a lot of time going back and forth about what happened 6 years ago. I apologize for not being able to recall a lot of that stuff from memory. That's a long time ago, a lot of water under the bridge. And I understand, you know, the reasoning behind the questions. You all have questions, there's a letter of concern out there. Sure, it's certainly something to be considered. But I want to circle back to, you know, if this happens again, ever happens again, make sure that you follow the rules of due process. Make sure that there's a proper and official investigation. The whole process within the judicial system. This back and forth stuff, like I stated in my statement, had that process begun at the onset, we wouldn't be here spending many hours talking about what could have been, what could have been done better. But I wanted to take this opportunity to discuss, you know, we've spent a lot of time talking about the old stuff, but we haven't had time to talk about the good stuff, the new stuff. You know, you real quick, you brought up, you know, us interviewing KCOA board trustees. Well, the reason we wanted to do that is because if you have a board, just like you are a legislative body and you all have to work together to get along. The KCOA operates on the same premise. We wanted to diversify the skill sets of each director. Someone that would complement the board, complement the tribe. And you know, I'm sad because Marcy's no longer on the board. I'm sad because Sean's no longer on the board. Because we had a very good diverse skill set. You know, Sean had a lot of IT background. And what's the backbone of a casino? It's IT. I have a lot of IT background, so we were able to, you know, look at systems, improve systems, find areas of efficiencies. Arthur, being a former gaming commissioner, brings that regulatory side to the board, and that's something the board has to have. Arthur keeps us in check. He confers with our own game commission, make sure that they're in check. You know, TW with his legal background and his Chickasaw experience, he complemented the board very well. Marcy is the best administrator I've ever known. She is a hardball, she gets things done, and she lives up to her word. You know, so when we want to be involved in director, you know, we just want to make sure that we're getting the best and giving the best to the tribe. But again, going back to this current board, which I hope that we spend more time on today, but you know, just going over some of the positives that we've done. You know, we took a fledgling industry, we completely changed the culture. I think if you interview any employee at the casino, they will tell you that the changes that this board has been part of in making have significantly increased morale. We've cut costs, we found every area of efficiency, and we're still working on it. Once we get these departmental budgets in line, you know, we'll know to the penny where we're spending, and we can reassess and reevaluate things. We developed a strategic plan. You know, and that's a great thing. I don't know that any board ever had that. Surely, you know, I'm not gonna be dismissive. There probably were other boards, but I just don't have that knowledge. But we had a great plan going forward. Look at what we did, you know. We spent wisely. We invested wisely. You know, you might be able to get 4% with this Cohen investment guy, but we were getting 3%. That's a pretty good return on investment. We didn't lose any money. We passed every audit. But we saved a lot of money that was going to be reinvested back into the tribe that would have provided additional resources back to the tribe. You know, I'm disappointed about the $35 million hotel expansion because that would have been a huge win. The feasibility study said that we would have had it paid off in 4 years and would have guaranteed at least, you know, $7 to $10 million back in revenue. That's additional revenue that could have gone back to the tribe. You know, we could have used cash on hand to pay for that expansion, but we had other projects in the work. That's why we went to the KIC to secure a loan. Because if you've ever run a successful business, you know You don't spend all your cash reserve, you don't spend all of that. You know, if you can protect that and reinvest that, that's what's best for the tribe, and that's what we were doing. Ben, you wanted a hotel in Hobart, well, we were planning that. We were planning future developments to develop that property and bring additional revenue. But, you know, that's all gone. You know, we were looking at other markets, we were looking at potentially, Eric. Elgin. There were a lot of different other opportunities that we were looking at. But ultimately. This board, this CEO. This Kiowa team that we've got working in our enterprise, they're all good people. And we've done some significant things. So I just wanted to get that on the record because I'm proud of the job that Bob has done. I'm proud of Denise, you know, for getting the financials back in order. I'm proud of our Secretary Stephanie, and I'm extremely proud about Coy, our chief CCFO. You know, Coy has done an outstanding job. I mean, look at how much money he was able to save during the Hobart construction project. And we're debt free. You know, and I said it before, I'll say it again. Anyone who can take an enterprise and get them completely out of debt and amass a huge savings account, that's championed in the real world. But for some reason, in this arena, it's a bad thing, and I just can't wrap my head around that. But you know, at the end of the day, the KCOA is trusted with the money to grow it, and that's what we did. You know, it's just unfortunate that we have to be overshadowed by this stuff that happened, you know, in 2018, 2019. Understandably, it was high gain.
Time, so 5 minutes.
Thank you.
Thank you, Mr. McMahon. At this time, open it up for any questions from any of the other legislators. If there are no more questions.
I just want to thank Mr. McMahon for appearing today. Thank you for his time and everybody for coming out and from the legislative standpoint, you know, this is just fact finding, trying to figure out and publishing a report, figuring out where we go from here. For me, it's about making sure that, you know, that doesn't happen again, you know, like all the problems, you just said it, high gain, you know, that's the way it was ran before. We want to make sure, you know, part of our responsibility as a legislative branch is having oversight over government actions. The casino is part of the enterprise, is part of the tribe, right? And it's the tribe's money y'all are managing. So we're just exercising our legislative powers by asking the questions because gosh, 75 pages of or you know, 75 documents over 1,000 pages have been generated by this hearing. It's a lot to understand and clarify. So I just appreciate you coming here and being willing to answer our questions. I think the next part of this process is also, I've been a part of those meetings, you know, that you mentioned before, no due process. And it seems like historically, that's always been a problem within tribal government. Not just our tribal government, all tribal governments, you're guilty just by somebody accusing you of something, right? So we understand, I understand that. I think my fellow legislators understand that this is part of the due process, just to make sure you're heard. And we're asking questions. And we want your thoughts and or what actually happened and publish a report. Hopefully we'll figure out where to go from here and publish some recommendations. How do we fix this? So I think that's what today was all about. And I want the citizens to know we're only exercising our legislative powers to have that oversight. And so hope you understand it, but thank you for coming today. I hope.
I want to say one thing is, I just want to say, did an excellent job bringing Hobart Casino. Y'all doing a really good job. I really want to say appreciate y'all guys. Through all the means, I say thank you for showing up. I really do. And God bless you and your family, for everybody who traveled and everybody over to Zoom. I just want you to know that. God bless you. I turn it over.
Yes, legislator Wolf.
I want to say thank you as well. I look at our gaming, our revenue, our only revenue maker and tribe, so important to our success of the Kiowa tribe, where we're headed. Yeah, I'm very proud of Colbert. It's been a long journey, very difficult. I know everyone knows that, what we've gone through, the robbery, the monies, everything lost. I do have a concern for the future of our gaming, and my concern is to see more Kiowas in key roles in operating our gaming. We see more training there being for our Kiowa people to make our tribe more productive with our revenue. I do know that this is an opportunity, and I appreciate the answers and during the questions, you know. But eventually for the future, I do hope that we can provide more training for more Kiowas to be employed in our key positions of our gaming, because we seem to lack that, and it's so important. That's how we set these gaming programs up, or why we set them up. Thank you.
Oh, for that.
With motion, when you get there.
I'd like to say thanks for your time and testimony there too. And I don't have any questions at this time, so. I'm left over.
Okay, at this time, I also would like to thank everyone who has attended today, as well as everyone on Zoom. Thank you for your time. And I believe there's a motion.
Second it.
To adjourn. Motion made by legislator Wheaton, seconded by legislator Fatality. Motion to adjourn. All in favor, say aye.
Aye.
Any opposed? Any abstentions? We are adjourned.